You walk out that drive, and I will personally make sure they find you face down in the Colorado River." The words don't echo. Concrete absorbs them. Reed Calloway says it the way a man says something he has rehearsed, something he has said before, in other parking garages, to other people who made the mistake of believing the wrong person about the wrong thing at the wrong time. He is 6'3" and 240 pounds, and he is standing between Sandy Wren and her car, and his right hand is already moving toward the canvas bag on her shoulder. She doesn't step back. That's the first thing that surprises him. They always step back. She stands in the fluorescent half-light of level B2, her bag held at her side, her breathing even, her eyes tracking not his face but his hands. His right hand. The distance between his knuckles and her shoulder. The exact number of steps between the concrete pillar behind her and the stairwell door to her left. She has been measuring distances her whole life. Reed Calloway has spent his whole life never having to. He lunges for the bag. She pivots left, not running, just rotating, 1 step and a quarter turn. And his hand closes on air. He stumbles forward 2 steps, catches himself on the hood of a parked Civic. He turns with his jaw set, and his eyes doing the thing they always do when men like him discover that the script has changed. "You think this is a game?" He straightens, rolls his neck, steps forward, closing the distance, putting 240 pounds between her and the exit ramp. His right hand shoots out and grabs the strap of her bag. Hard. The kind of hard that is intended to leave a mark, intended to communicate something beyond language. "Give me the drive." She doesn't pull away. She looks down at his hand on the strap. Then she looks up at him. "Pillar C7, she says, quietly, not a threat, a fact. "You've been on camera for the last 40 seconds. He looks up at the camera mounted on the concrete pillar 8 feet above them. He looks back at her. His hand releases the strap. She is already at her car. Reed Calloway had just put hands on the wrong woman. Inside that bag was the one thing Sterling Vance had no defense against, and neither of them knew it yet. He had called her unstable in 3 internal memos before this moment. He had told his supervisor she was a flight risk with sensitive proprietary materials. He had written in his incident log, dated 2 days before this confrontation, in language clearly prepared by someone with a law degree, that Sandy Wren had been displaying erratic behavior consistent with disgruntled termination. Sterling Vance's legal team had reviewed and approved every word. What none of them knew, what Reed Calloway could not have known as he stood in level B2, watching her pull out of the parking structure and into the Austin afternoon, was that the hard drive in her bag contained something they could never erase. Not with Miles Fenwick's server access, not with Andy Rice's forensic tools, not with 41 pages of federal filing and a battery of IP lawyers and a public relations campaign that had started before Sandy even knew she was being targeted, because the thing she had built, the thing they had stolen, carried her name inside it, not in the metadata, not in the file headers, not in any layer that a search tool could find and a deletion tool could remove. Deeper than that, in the machine code itself, in a sequence of bytes occupying a specific location in the compiled binary that looked like padding, looked like alignment artifact, looked like nothing, unless you knew exactly what you were looking for and you had the key to read it. They had picked the wrong engineer. That was the whole of their mistake, stripped of everything else. They had chosen a target who had learned a technique from an anonymous forum post 3 years earlier from a man whose name she did not know until now, that no metadata scrub in the world could reach, and they had no idea. If you've ever watched someone's work get taken and their name erased from it, this story is going to hit differently. Subscribe and stay with me, because what Sandy Wren did next took 2 years and cost her almost everything she had. And it was still worth every single day. She sat in level B2 for 4 minutes before starting the engine. She pulled the termination agreement from the outside pocket of her bag. 7 pages, cream-colored paper, Vance Systems letterhead, the company logo embossed in gold at the upper right, and turned to page 5, paragraph 11. Subsection B. She read it aloud to herself in the quiet of an underground parking structure, in a voice that did not shake. Employee hereby assigns, transfers, and conveys to the company all right, title, and interest in and to any and all intellectual property created, developed, conceived, or reduced to practice by employee, in whole or in part, during the employment period, or that relates to or was derived from the company's business, technology, or research, including without limitation all copyright, patent, trade secret, and other proprietary rights therein, such assignment to be perpetual, irrevocable, worldwide, and royalty-free. Perpetual, irrevocable, worldwide. She had signed it 31 hours ago, 61 hours without sleep, a pen in her hand, 7 pages of what had looked like routine termination paperwork. They had timed it. She understood that now, sitting in the concrete dark, understanding assembling itself with the clarity that comes when you finally have all the pieces you needed. They had waited until she was running on nothing and placed a document in front of her designed to look like one thing and function as something else entirely. She folded the paper and put it back in her bag. She started the engine. She pulled into the Austin afternoon and drove west, and she did not cry until she was 3 miles from the Vance Systems campus. Then she cried for exactly 11 minutes. She had learned, a long time ago, to give grief a time limit. Her phone lit up on the passenger seat. 3 missed calls. Unknown number. Area code 512, Austin. But the exchange was wrong. 734. She recognized that exchange the way she recognized certain compiler errors. Not from memory exactly, but from the pattern, from the context in which she had once encountered it. A file she had read years ago. A legal case, sealed under confidentiality agreement in 2013. A man named Kai Oduya. The exchange belonged to a prepaid cell registered to a business that had been dissolved in 2014. She stared at the number. The screen went dark. She did not call back, not yet. Not until she understood exactly what she had and exactly what she was going to do with it. 14 months earlier, Sandy Wren had arrived at Vance Systems on a Tuesday in September, carrying a backpack, a stainless steel thermos, and a notebook she had already filled a third of. She was 33 years old. She had grown up in Decatur, Georgia, the daughter of a high school mathematics teacher and an electrician, in a house where problems were considered interesting rather than threatening, where the answer to "I don't understand" was always "let's figure it out" rather than "you should know this already." She had learned, early and well, that understanding was not a state you arrived at. It was a practice you maintained. You kept notes, you dated everything. You underlined what mattered and kept the paper. By the time she graduated from Georgia Tech with her master's degree in computer science, she had filled 47 notebooks. She was not sentimental about them. They were not diaries. They were records of problems she had encountered, approaches she had tried, solutions she had built, and the date and time and circumstances of each. She kept them because they were useful. She kept them because a thing documented is a thing that exists in a way that an undocumented thing does not. She spent 4 years at a machine learning company in Atlanta, doing work that was good and valued and intellectually interesting enough to sustain her. She built her reputation in the specific way she preferred to build things, quietly, thoroughly, with the kind of documentation that left no ambiguity about what she had done and when and how. She published twice in peer-reviewed journals, presented once at an academic conference in Chapel Hill, and spent 2 years of her own time, evenings, weekends, the occasional sleepless stretch, working on a problem that she had first encountered in the literature and found impossible to stop thinking about. The problem: real-time contextual learning in AI inference without retraining cycles. Every serious approach to it required taking the model offline, retraining on new data, and redeploying, a process that could take hours or days and made true real-time adaptability impossible. She had an idea about why the standard approach was structurally limited and a developing sense of a different architecture that might solve it. She worked on this idea in her personal Git repository, on her own equipment, on a server she paid for herself. She had been working on it for 2 years when she read the 3rd paragraph of Vance Systems' job posting. The technical interview lasted 45 minutes. 2 engineers, one she would later know as Prashant, one whose name she never learned, gave her a collapsed inference pipeline on a whiteboard and watched. She rebuilt it in 42 minutes. She identified 2 secondary failure points that had not been part of the original problem. She explained her reasoning in the language of someone who has not merely studied material, but inhabited it. Prashant looked at the other engineer. The other engineer looked at Prashant. Neither of them said anything for a moment. "One more question," Prashant said. "Not on the board. Just, how long have you been thinking about the contextual learning problem?" "About 2 years," she said. "Do you have anything to show?" She described the repository, the commit history, the architecture she had been building. Prashant asked questions that grew more technical, and she answered each one. After 20 minutes of this, he put his pen down and said, "I think we're done with the interview." She thought she had failed. She was wrong. Harlan Cross was the final round. Harvard MBA, 62 years old, the particular kind of confidence that accretes over decades of being the smartest person in most rooms. He was polished and engaged and asked questions that demonstrated genuine technical interest. But there were 2 phrases. "For someone at your level," he said, the first time, with a pause after level that carried the architectural implication of a ceiling he had already placed and was now generous enough to acknowledge. Given your background, he said, the second time, with a micro-inflection on background that contained a category of assumptions he would not have been able to name under direct examination. She answered every question precisely. She did not perform enthusiasm she did not feel. She did not smile at moments when smiling would have been expected, but not authentic. She was what she was. Thorough, exact, technically fluent in the specific domain they needed. And she let that stand. She got the job. Cross had recommended a mid-level trial period. Prashant and the other engineer had gone to the CTO and said, in different words, the same thing. Hire her at full senior level or watch her solve this problem for someone else. She started the first Monday of September. 3rd floor, south side, near the windows. She organized her desk on her first morning before touching any company equipment. Laptop in the upper left corner, lit at 90 degrees. Thermos to the right, cap unscrewed. Personal notebook, black, hardcover, college ruled, open flat beside the keyboard. 3 pens in a row, blue, black, red. She wrote the date at the top of the first page and underlined it twice. Miles Fenwick, whose desk was adjacent to hers, watched this ritual from the corner of his eye. He had the expression of someone watching something that interested him more than he intended. Company issues digital notebooks, he said. Cloud synced. They're actually pretty good. I know. She uncapped the blue pen. I prefer paper for things that matter. Miles was 31, lean, with the kind of cognitive energy that made him seem perpetually half a step ahead of whatever conversation he was in. He was quick and technically gifted and socially easy in the way that made difficult rooms feel smaller and easier to navigate. He had a habit of staying past midnight, not because anyone required it, but because the hours between 10 and 2 were, for him, the only hours when the noise of an open-plan office cleared enough to let him think. The same was true for Sandy. That was the beginning of it. Not dramatic, not a moment. Just 2 people who worked best in the dark, on opposite sides of a desk, in an office that belonged to everyone else during the day and was essentially theirs after 10. They did not become close quickly or easily. It happened the way useful things happen, through shared work and shared silence and the slow accumulation of evidence that each could trust the other's judgment. Miles brought coffee. She never asked him to. He noticed early that she ran out at roughly the same point every evening, and he corrected for it without comment. She provided the particular quality of silence that let him think. She had learned that some people need quiet the way they need oxygen, that silence is not the absence of collaboration, but its deepest form. He made her laugh occasionally, with the precision of someone who had learned that the best humor is precise observation, not performance. He was the first person in Austin who asked about her work. Not in the language of evaluation, not in the language of oversight, but in the language of someone who was genuinely curious about the process, who wanted to understand not just what she had built, but how she had arrived at it. She trusted him. That was the unadorned truth of it. She trusted Miles Fenwick the way she trusted a well-documented code base, completely, without reservation, right up until the moment she found the error that everything else had been arranged to conceal. That moment was 14 months away. In September, October, November, December, January, February, and on through the summer, she worked. The project was named ARIA, Adaptive Reasoning and Inference Architecture, a name that marketing had reverse-engineered to fit the acronym after someone who had not read the technical documentation decided the system needed a name that sounded human. Sandy had not named it. She had built it. October brought the first major architecture review. She presented the inference layer design to the full engineering team in the large conference room on the 2nd floor, a room whose whiteboard had been used so many times the surface was permanently gray. She stood at the board for 90 minutes. She drew the dependency graph from memory, not because she was performing, but because she had been living inside the architecture for long enough that it occupied the same mental space as her own street address. When she was done, Prashant, who had been in her technical interview, who had made the call to hire her at full senior level, sat in the back of the room with his arms crossed and his expression doing something she did not see from the other engineers. He was looking at the board with the focused attention of someone seeing something they had suspected was possible and were now watching be proven so. After the meeting, in the hallway, he stopped beside her. "That's not adapted from anything I've seen in the literature," he said. "No," she said. He looked at her for a moment. He nodded once. He went back to his office. She wrote it in her notebook. Not the compliment. She did not keep a record of compliments. She wrote the date and what the board had contained, and that she had drawn it from memory without reference materials. She photographed the board before she erased it. November was the crash. 3 failed builds in a row, each one producing the same cascade failure in the output buffer when the inference model exceeded a certain data density threshold. She and Miles worked through 2 consecutive nights. The office lights dimmed on their automatic schedule and came back up and dimmed again, and the city outside the third-floor windows went dark, and then gray, and then light, and they were still at their desks. Miles brought coffee. She brought the particular quality of focus that she sometimes worried was close to obsession, but had learned over years to distinguish. Obsession runs from something. This ran toward something. The problem was there. It had a shape. It would yield. It yielded at 4:17 in the morning on the 3rd day, when she identified a memory allocation conflict in the buffer management layer that was specific to her architecture, that could not have appeared in anyone else's work because it was a consequence of a design decision she had made that no one else had made in the inference pipeline. She found it the way she had been taught, as a child, to find errors in mathematical proofs, not by looking for what was wrong, but by following the logic forward until the place where the logic and the result diverged. She wrote the date and time in her notebook. Blue pen, underlined. Then she fixed it, and ARIA built clean. December brought the first full system demonstration, internal only, executive team in the main boardroom, with Sterling Vance himself present via video link from San Francisco. He watched the demo on a conference call screen. He asked 2 questions. Both questions were about market timeline and IP protection. Neither was about how the system worked. He had the particular attention of a man who was interested in a thing's value, not its nature. Harlan Cross, sitting 3 chairs from Sandy and never addressing a remark directly to her, asked 11 questions. They were technical, and she could see him listening to her answers with the expression of someone resolving a cognitive dissonance, the fact of her competence pressing against the assumption of her limitations in real time, and the assumption losing quietly, without acknowledgement. She wrote the date in her notebook. She underlined it. She noted who had asked which questions and what the answers had been. Not alone. 4 other engineers, a data specialist, a quality assurance lead, contractors who rotated in and out on specific modules. They contributed. Their contributions were real and mattered, and are not the subject of this story. The central architecture, the thing that made ARIA distinct from every other adaptive inference system on the market, the thing that made it capable of contextual learning without taking the model offline, the thing that Sterling Vance would eventually demonstrate before a United States Senate subcommittee on technology and innovation and describe as a historic breakthrough in American artificial intelligence that will define the next decade of human-machine collaboration. That architecture was Sandy's. Specifically, it was a method she had been developing for 2 years in Atlanta, in her own time, in a personal Git repository on a server she paid for herself. Documented in personal notebooks, committed with timestamps, hash-verified, and, in one particular implementation, one she had built after receiving documentation through an anonymous post on a security research forum 3 years earlier, documentation she had implemented and adapted and made entirely her own, signed. Not a watermark. Not a comment header that could be stripped. Not metadata that a competent engineer could overwrite in 30 seconds. Signed in the compiled output, in the bytecode itself. In a sequence of bytes occupying a specific location in the binary, arranged to look like compiler alignment padding, to look like nothing. Unless you had the key and knew where to look. At the time, she thought of it as a habit. The same instinct that made her date every page and underline it twice. The same impulse that kept 3 pens in a row. A documentation practice applied to a layer of the work most people never thought to document. It would become the most important decision of her professional life. But that understanding was still ahead of her. The first provable microaggression, the first one she could document with precision, came in February at a project review meeting where she presented the first functional build of ARIA's contextual inference layer. 12 people in the room, including Harlan Cross at the far end of the table, and Sterling Vance's product director, dialing in from San Francisco. She spent 22 minutes on the architecture. She used slides she had built herself, with diagrams she had drawn, to explain a system she had designed. The room asked good questions, and she answered them. At the end, Cross leaned back in his chair and said, with the casual confidence of someone who is not checking his assumptions before speaking them, "Impressive. Who helped you structure the core logic? Not, how did the team approach this? Not, walk us through the collaborative process. Who helped you? 2 seconds." She held his gaze for exactly 2 seconds. "I structured it," she said. No heat, no edge, just the fact. He nodded the way he nodded at things he had expected, which told her he had asked the question knowing the answer he assumed he would receive, and that her answer had not changed the assumption, merely noted an alternative possibility that he was choosing to set aside. She wrote it in her notebook that evening. The date, the time, the room number, the exact words. Blue pen. The second came in March, when Britta Voss, Chief Communications Officer, 42, a practitioner of the particular art of weaponized warmth, made one of her quarterly visits to the engineering floor. Britta walked through a space and made mental notes and called it a culture check-in. She had a talent for making this feel like genuine attention. She paused at Sandy's desk, looked at the organized surface, notebook open, pens in their row, thermos at its consistent angle, and said, "Oh, how organized. Are you naturally like this, or did someone teach you?" Sandy looked up. She held Britta's gaze for one beat. "Both," she said. Britta smiled the specific smile of a woman who has been given an answer she will file and not use. She moved on to Miles's desk and laughed at something he said that Sandy could not hear. The third came in May. A technology publication ran a profile of Sterling Vance. The sixth paragraph mentioned ARIA as conceived and developed under Vance's direct supervision, led by his hand-picked team of engineers. 4 engineers were quoted in the piece. Sandy was not among them. Miles was. His quote described the collaborative environment at Vance Systems. He did not say her name. She printed the article. She added it to the folder she had started. She went back to work. She solved the inference latency problem she had been working on for 3 months. A memory allocation restructure that required 2 sleepless weekends and the kind of obsessive precision that she had been applying to problems since she was 9 years old, and her father had given her a calculator and told her to find the largest prime number it could hold. She solved the problem in 16 days. On the 17th day, Miles brought coffee at 2 in the morning and sat on the edge of her desk and said, "You know what the problem with being this good is?" She looked at him. "Nobody believes it's you." He said it lightly. But something beneath the lightness was not light, was in fact the opposite of light, was the quality of something said by someone who knows more than they are saying and is making a choice about how much to reveal. She picked up her blue pen. She wrote the date and underlined it twice. Miles watched her write. He was quiet for a moment. Then he looked away. She kept writing. The termination meeting was on a Wednesday afternoon. They chose 4 o'clock. They had not chosen it by accident. By 4 o'clock on a Wednesday, Sandy had been awake for 61 hours. She had been working a critical output layer bug since Monday morning, had isolated it, understood its structure, was 3 hours from the solution when her calendar notification appeared. Mandatory HR meeting. Conference room 4B, 4 p.m. No additional description. She saved her work. She went downstairs. The HR representative was named Sandra. She had a warm voice and a legal pad, and the practiced neutral expression of someone who has delivered difficult news enough times to have developed a professional relationship with their own discomfort. Beside Sandra was a man Sandy had not met. Hartwell, late 40s, gray suit, the specific stillness of someone who has sat in many rooms like this one and knows in advance how they end. The termination agreement was 7 pages in a cream folder with the Vance Systems logo. Sandra slid it across the table with the unhurried motion of a woman who has done this before. Hartwell had a copy open in front of him. He did not look at it. He looked at Sandy. She was more tired than she had been in years, not just from 61 hours awake, but from the accumulated weight of 14 months of small transactions, the look from Harlan Cross, the smile from Britta Voss, the article with 4 engineers named and her name absent, the cumulative energy expenditure of being underestimated in every room she walked into and choosing, each time, not to address it directly because the work mattered more. That kind of fatigue is different from sleep deprivation. It settles in layers. By the time she sat down across from Sandra and Hartwell, it had settled deep. She read the summary page. She read the severance terms. She read the confidentiality clause on page 3, which was standard and did not concern her. She noted the dates. She checked the math on the severance calculation. Everything appeared routine. Everything was designed to appear routine. She did not read page 5, paragraph 11, subsection B. She signed. Sandra thanked her with the warm efficiency of someone who has been trained to make this interaction as brief as possible. Hartwell closed his briefcase. Reed Calloway appeared in the doorway. She had seen him twice before, at a distance, and knew he was head of building security without having had reason to think about what that meant. She had 15 minutes for her personal items. She took her notebooks, all 6, 1 per month of her employment, plus the pre-employment one that contained 2 full years of development work documented before she had ever applied to Vance Systems. She took her 3 pens. She took the folder from her bottom drawer, the one with the printed article and the growing collection of small documentation. She did not take anything from the company server. She had never stored anything personal there. She had known, from her first week, to keep her personal work personal. Reed Calloway watched her pack. He did not speak. She did not look at him. In level B2, in the dark of her car, she pulled page 5 from the folder and read it under the interior light. She read it word by word at the pace of complete comprehension, the way she read code, the way she read everything that mattered. Perpetual, irrevocable, worldwide. She read it 3 times. Then she sat for 14 minutes in the silence of an underground parking structure and understood, with the particular clarity that comes when you finally have all the information you needed, what had been done to her. Not fired, disarmed. They had waited until she was running on nothing and placed a document in front of her designed to look like one thing and function as something else. A legal transfer of everything she had built, everything she had spent 2 years developing before she walked through their doors, wrapped in standard-looking termination language that most people in her condition, exhausted, surprised, emotionally beaten, would not have read to the bottom of page 5. Most people, but not all people. She was already cataloging what she had, what she could prove, the notebooks, the Git repository, the hash-verified timestamps, the technique that existed in the binary itself that no lawyer and no server wipe and no forensic cleanup crew could reach. Reed Calloway appeared at her window 20 minutes later. He wanted the drive. She stepped out. He grabbed the strap. She pivoted. He stumbled. She pointed to C7. He told her about the Colorado River. She was in the car before his breathing had recovered. 3 days after the parking garage, Britta Voss gave an interview to a technology outlet. The piece ran under the headline, Vance Systems addresses, disgruntled former employee claims before ARIA launch. Sandy had made no public claims. She had filed nothing. She had spoken to no journalists. She had not yet taken any action visible to anyone outside her apartment. She read the article twice. Disgruntled former employee appeared 4 times. Unstable claims appeared once, attributed to a source close to company leadership. Baseless allegations regarding proprietary technology appeared in the second paragraph, describing a dispute that had not yet been publicly acknowledged as existing by either party. Britta Voss had built the frame before anyone had a picture to put in it. She had established the narrative container, disgruntled, unstable, baseless, and ensured that when Sandy's story eventually became public, it would arrive already categorized, already diminished, already pre-answered. This was the professional violence of it. Not loud, not visible, conducted entirely through language and publications that reached the people whose opinions would matter. On the 4th day, Sandy called the United States Patent and Trademark Office General Inquiry Line and asked about the process for registering a copyright in software architecture. She took notes, date, time, the name of the person she spoke with, the reference number of the call. Black pen. On the 5th day, she opened LinkedIn and searched Miles Fenwick's name. The update had been posted 3 days earlier, 1 day after her termination, 2 days before the Britta Voss article. Thrilled to announce my new role as Chief Technology Officer at Vance Systems. 412 likes. She sat at her kitchen table and looked at the screen. The apartment was quiet. She thought about 14 months of 3 a.m. coffee. About the November night when the ARIA build crashed 3 times, and Miles had sat on the floor beside her, back against the server rack, and said, with the complete sincerity she had never had reason to doubt, "We'll fix it. We always fix it." She had believed him. She had believed him because he had been there for the fixing, had sat beside her for enough hours to understand, in precise technical detail, what she was building and what it would eventually be worth. Had been there, in August, during a server migration, on an afternoon when she had written a temporary access credential in a company-issued notebook on her desk and left for 40 minutes to attend a meeting. Miles had been at his desk the entire time. She had thought nothing of it. She was thinking of nothing else now. She went to the closet, took out the fireproof box she had purchased the day after the termination, retrieved the folder with the termination agreement. She read Clause 11b again. Then she opened her procedural folder and wrote at the top of a new page, in red pen, fraudulent inducement. Research Texas Common Law, plus Restatement Second of Contracts, Section 164. She underlined it twice. A letter from Vance Systems Legal arrived 4 days after that. 11 paragraphs. Clause 11b, violation. The hard drive. 72 hours. Legal proceedings under 17 U.S.C. Section 101 and the Defend Trade Secrets Act, 18 U.S.C. Section 1836. She read the letter 4 times. Then she called Priya Suresh. Priya practiced IP litigation in Austin and had a reputation, among the people who paid attention to such things, for being the kind of lawyer who did not use more words than the situation required. She read the legal letter in the time it took her to finish half a cup of coffee, then set it down with the flat deliberateness of someone who has finished considering a thing and reached a conclusion about it. Federal play, she said. DTSA and copyright, both. They're not probing. This is full-scale pressure designed to make you fold before you have time to organize. What do you have? Sandy placed the pre-employment notebook on the desk. Development notes, dated 16 months before I joined Vance Systems. The core architecture of what they are now calling their product is documented throughout. She placed the Git log printout beside it. Personal repository, 18 months of commits before my employment, each hash verified. The repository is on a server I maintain independently, and the commit timeline has been blockchain timestamped. Priya examined both documents with the focused attention of someone who understands what she is looking at. Then she looked up. Is that it? No. Sandy placed her hands flat on the desk. There is one more element. It cannot be presented in this meeting because it requires forensic authentication that I don't yet have. But the architecture of the system they are claiming, the binary output of the compiled code, carries embedded information. Embedded at a level below the file system. Below the metadata layer, in the compiled output itself. Priya waited. The information identifies me, Sandy said. By name, with time-stamped verification. It cannot be removed without destroying the functionality of the system. Priya was quiet for a long moment. A stillness that was not uncertainty, but the particular quality of attention a trained mind gives to something that requires recalculation. If that is authenticated, she said, and if it says what you say it says, it changes the entire structure of this case. I know. Who can authenticate it? I'm working on that, Sandy said. I need a specific kind of forensic expert. Someone who understands compiled machine code at the binary level and can testify credibly in a federal proceeding. Priya nodded once. Find them. That's the priority. She closed her notepad. In the meantime, do not surrender the drive. Do not respond to the letter without my signature on it. And Sandy. She paused. They filed this fast, which means they anticipated you would fight back, which means they have been planning this for longer than you think. Sandy had already reached that conclusion. She had reached it in the parking garage. She was 3 steps ahead of where they thought she was. She intended to be 10. The 72-hour deadline passed without response. Sandy did not surrender the drive. Vance Systems filed suit 6 days later in the Western District of Texas, Austin Division. 41 pages. Plaintiff's Exhibits A through T. Decker Hull, listed as technical expert for the plaintiff, submitted a 12-page declaration arguing that ARIA's core architecture had been developed entirely within the company's infrastructure, by company personnel, using company resources, and that the system predated Sandy's employment by a full 8 months. Hull's declaration cited metadata from the company Git server, showing commit records dated 26 months back, 8 months before Sandy had applied for the job. It cited internal project documentation with timestamps, build logs, dependency trees, version histories, architecture diagrams with file creation dates. She read it 4 times. Hull was good, genuinely good. The declaration was technically fluent, architecturally literate, and internally consistent. He had done thorough work with the materials he had been given. The materials had been prepared by Miles Fenwick, who knew exactly what a competent technical expert would look for and had constructed a digital paper trail designed to provide it. What he could not have known was that paper trails are not the only trails. She wrote 1 sentence in her notebook. Blue pen, 1 underline. They don't know about the bytecode. 8 days after the first Britta Voss article, a guest column appeared in a major trade journal under Harlan Cross's byline. The title, Protecting Innovation in the Age of Disgruntled Talent, is 3,000 words of careful professional language about the challenges companies face when former employees with incomplete understanding of collaborative development processes misattribute their individual contributions to broader team efforts and pursue misguided legal remedies. 2 IP attorneys quoted, a business school professor. A reference in the final paragraph to the significant reputational and financial harm that such claims cause to the innovators who actually do the work. 37,000 subscribers received it in their inboxes. She printed it. 14 items in the folder now. She was reading it for the 2nd time at her kitchen table when the doorbell rang. Reed Calloway stood in her doorway in civilian clothes, jeans, a dark gray jacket, but he wore his body the same way he wore his uniform, as a statement about the distribution of power in any space he entered. 6'3", 240 pounds, the the forward lean of someone who has spent decades using his physical presence as his primary instrument. "You filed a copyright inquiry with the USPTO," he said. "We'd like you to reconsider." "Step back from my door," she said. "You're at my private residence, and you don't have permission to be here." He did not step back. He leaned forward slightly, not across the threshold, but enough to reduce the geometry of the doorway, to use the structural fact of his size to make the opening feel smaller than it was. His left hand moved to rest on the door frame above her head. His voice dropped half a register. "We can do this the easy way, Sandy, or we can make this very difficult for you. Your choice." She looked up at his arm. She calculated the angle of his elbow, the distance to the door handle, the clearance to her left if she needed to move. She had been calculating distances since childhood. The calculation took less than a second. "Texas Penal Code Section 42.07, she said. "Harassment by threat. I'm on the phone with APD non-emergency in 15 seconds. She raised her phone, keypad already open. 14. He looked at the phone. He looked at her face. The calculation behind his eyes ran its course. 13. He stepped back. He turned. "This gets harder before it gets easier," he said over his shoulder, and walked down her hallway and around the corner. She locked the door. She wrote the time and date and his exact words in her notebook. She photographed the page and uploaded it to the cloud account she maintained under a separate email address. 27 items in the folder. She was counting. Miles Fenwick called 3 days later. She answered on the 4th ring because she had decided she would. "I had no idea they were going to let you go," he said. His voice was the same, the quick warmth of it, the slightly ahead energy, as if 14 months of documented trust had simply not terminated. "That wasn't something I knew about." She waited. "I'm really sorry, Sandy. You deserve better from them." "Miles, did you give them my credentials? The temporary access code from the August server migration?" Silence. 3 seconds. 4. The particular silence of a person constructing, in real time, their response to a question they have been dreading. "It wasn't like that." "Did you photograph my notebook from my desk while I was in the meeting?" More silence. Longer. "Yes or no?" she said. In the silence that followed, the answer arrived without words. She had expected it. The expectation did not make it easier to hold. She met him the following afternoon at a coffee shop on South Congress. She had things to say, and she would not say them over a phone she was not certain was not being monitored. He was already there when she arrived, sitting in the back corner, hands around a cup he had not touched. He looked like a man who had not slept. She looked like a woman who had made a decision about what not sleeping costs, and decided the cost was acceptable. She sat down. She did not order anything. "You gave them my credentials," she said. He looked at the table. His hands moved on the cup. "They said it was a server audit, temporary access, that you'd never know." "And the CTO position." He looked up, his jaw set. He had the expression of someone who has rehearsed a version of events and is discovering in real time that the rehearsal was insufficient. "They were going to take it anyway," he said. His voice was lower now, something stripped of its usual fluency. "I could see it happening, the way they talked about the project in leadership. They were already treating it as theirs. I thought if I was inside, if I had a position, I could—" "Miles." He stopped. "I'm not here to argue with you," she said. "I came here to tell you something while looking at you." She waited until his eyes met hers. "I documented everything. 14 months of notebooks, every meeting, every date and time and exact word, including August, including what was on my desk and how long I was in the meeting." She held his gaze without expression. "When this case goes to federal court, and it will go to federal court, I will testify to all of it, and you will be subpoenaed to testify to what you did." He said nothing for a long moment. When he spoke, his voice was almost inaudible. "They have union lawyers. Vance has resources." "I know what they have," she said. She stood. She pushed her chair in. "I know what I have, too." She walked out. She was halfway down the block when she heard rapid footsteps behind her. He had followed her out. He was moving fast, past the calculated composure he had maintained in the coffee shop, and something rawer was driving him now. Not guilt exactly, or not only guilt, but the specific desperation of a man who has made an irreversible decision and is beginning to understand what irreversible means. "Sandy, stop, please. You have to understand." He grabbed her arm. Not with force, not the grab of Reed Calloway reaching for a bag, not a deliberate act of intimidation. It was the desperate grip of someone who believes that if they can hold on to something long enough, the world will slow down enough to let them fix it. His fingers closed on her elbow, and and turned her half around. She looked at his hand on her arm. She looked at his face. He let go. He stepped back. He turned to the brick wall beside them and drove his right fist into it. The sound was flat and wrong, the sound of bone meeting surface at full intention without the cushion of second thoughts. He stood with his back to her, his right hand hanging at his side, his breathing uneven. "I'm sorry," he said, to the wall. I'm sorry." She looked at his hand. The knuckles were red and already swelling. She looked at his back. "I know," she said. "That doesn't change what you did." She walked away. He did not follow a second time. She documented the encounter that evening. The words, the grip, the fist against the brick, the name of the street, the name of the coffee shop, the time of day, the color and swelling pattern of his knuckles at the moment she last saw them. She photographed the notebook page. She uploaded it, 34 items. Reed Calloway found her 11 days later in the lobby of the Austin Federal Building. She was waiting for an elevator after dropping discovery paperwork at the clerk's office. Priya had filed a motion for emergency discovery of Vance Systems' internal communications regarding her employment. She was carrying her bag and a stamp receipt from the clerk and an untouched coffee. She was thinking about Decker Hull's declaration, about the specific metadata timestamps he had cited, about the question of whether manufactured metadata could survive the scrutiny of an independent forensic review. He came through the main entrance with the focused economy of someone who had timed this carefully, someone who had access to her filing schedule, which meant either her attorney's office was being monitored or someone in the courthouse had been asked to flag her appearances. She noted this and added it to the list. He crossed the lobby in 8 steps. He grabbed her by the shoulder, not the strap of her bag, but her shoulder itself, his full hand, the grip of someone not trying to stop her but to move her, and used his momentum to shove her sideways and back into the marble wall beside the elevator bank. Her shoulder hit the marble, and the impact traveled through to her collarbone and spine. The coffee fell. He had her backed against the wall with his forearm across her chest before she had taken a breath. His face was close. His voice was very low. "You filed discovery on internal communications," he said. "That is a line you should not have crossed." Her voice, when it came, did not shake. "Federal building," she said. "Security cameras on every wall. You have approximately 4 seconds before a marshal notices." His forearm pressure did not ease. He was calculating. 3 seconds, she said. He stepped back. He straightened. He adjusted the front of his jacket with the practiced motion of a man who has been in enough altercations to know how to look afterward like he hasn't. "Is there a problem over there?" A federal marshal in uniform was moving toward them from the security station 20 feet away, one hand on his radio. Reed said miscommunication 3 times. He said it smoothly, professionally, with the expression of someone describing a minor social misunderstanding. He was very good at this. He had clearly done this before. She said, loudly and clearly, "I would like to make a statement, please." And then at a volume only Reed could hear, "The timestamp on this photograph already has your face in it." She showed him the screen. The photo had been taken during the shove, a reflex she had practiced until it was automatic. The marshal took her statement. He took Reed's name and identification. He was professional and thorough. Reed Calloway identified himself, said there had been a misunderstanding, and left the building. A man who knew exactly how to not escalate a situation he had already escalated far enough. She documented everything on the building steps while the October afternoon cooled around her. The marshal's name, his badge number, the time of the initial contact, the force of the impact against the wall, the exact words used. She photographed the page. She called Priya from the steps. "Reed Calloway assaulted me in the Austin Federal Building," she said. "I have photographic documentation and a witness statement." A pause. "Were you hurt?" "No. But it's on the Federal Building security footage." "I'm filing a complaint with the U.S. Marshals Service tonight," Priya said, "and adding this to the discovery motion. This is 18 U.S.C. Section 1512 territory. Witness intimidation. If they've been coordinating this..." "They have been," Sandy said. "Someone had access to my filing schedule." Another pause. Longer. "I'm going to have my office swept for monitoring devices tomorrow morning," Priya said very quietly. "Good," Sandy said. She went home. She changed her shirt. She spent the rest of the evening adding to the folder. 42 items. She did not yet know the name of the man who had tampered with her tire. She knew his type, knew it the way a person who has spent years understanding how systems fail knows to look not at the surface of the failure, but at its architecture, the underlying structure of choices that produced it. Reed Calloway was the visible instrument. The tire, the apartment, the printout centered on her counter with its aligned corners. Those were the work of someone different. Someone Vance had paid through a channel that would take Priya's discovery motion months to reach, if it reached it at all. His name, she would learn later, was Andrew Reese. Andy to the people who paid him, though there were not many of those, and they did not call him by name in written communication. He was 44 years old, former private security for 3 technology companies, 2 of which had faced significant litigation and 1 of which had settled for terms that were never made public. He was not on any employee roster at Vance Systems. He appeared in no organizational chart. His engagement was through a consulting firm incorporated in Delaware, whose registered agent shared an address with 6 other shell entities. He was, by any professional measure, very good at what he did. He did not threaten, he did not confront. He operated in the register of ambiguity, incidents that looked like bad luck, mistakes that looked like carelessness, pressure that looked like coincidence. He had modified the valve stem on Sandy's car at 6:48 in the morning of the Tuesday the incident occurred, in the parking structure of Priya Suresh's office building, in 3 minutes and 40 seconds, using a tool that left no marks visible to casual inspection. He had coordinated the gray pickup through a contractor he paid in cash. He had accessed Sandy's apartment using a bypass device for the biometric lock that had a retail value of approximately $900 and was technically illegal to possess in the state of Texas, but widely available to people who knew where to look. He had placed the printout on the counter because he had been asked to. He had placed it precisely, corners aligned, centered, because precision was how he communicated. It was his signature. Not the kind that could be authenticated in court. The other kind, the kind that told you exactly what kind of person you were dealing with. Sandy did not know any of this yet. What she knew was the architecture of the pressure, its timing, its escalation pattern, its targeting of her documentary record rather than her person. Someone was trying to produce, in her, the particular combination of fear and exhaustion and isolation that makes people make decisions they would not otherwise make. She recognized the architecture. She had studied it in a different context for years. She was not going to make those decisions. What she was going to do, what she had been doing since the drive home from level B2, since the 11 minutes of grief and the moment the screen lit up with 3 missed calls from an area code with a wrong exchange, was document and prepare and find the person who knew what she knew and could stand up in court and say it in language a federal judge could not dismiss. The tire happened the following Tuesday evening. She was on Mopac Expressway, southbound, 6:44 in the evening. Center lane, 62 miles per hour. Traffic moving steadily. She had been on the road for 11 minutes from a meeting with a digital forensics specialist she had located through a professional referral. Not the right specialist, not the one she needed, but a step in the right direction. She was thinking about the meeting. She was thinking about the specific technical vocabulary she would need to explain the bytecode signature to a court. A gray pickup, which had been in the right lane behind her for approximately 2 miles. She had noted it without attaching significance to it, the way she noted everything, accelerated and cut sharply across into her lane. She adjusted left. In the same instant, synchronized, coordinated, the 2-vehicle execution of something planned in advance. Her right rear tire deflated. Rapidly, and with the controlled progression of a valve stem that had been compromised in advance and triggered remotely, not the irregular rupture of a road hazard. She did not know the mechanism at the time. She knew what it felt like. Hard right pull, center lane, pickup blocking her right, 62 miles per hour, no room to her right, a median barrier to her left, the specific configuration of variables designed to produce an outcome that would look like an accident. She controlled what she could control. Left hand high on the wheel, right hand low. The grip she had been taught in a context she had never discussed with anyone in Austin, one that was about maintaining control of a vehicle in conditions where control is what saves you. No hard braking. Counter pressure to manage the pull. She let the vehicle decelerate. She watched the gap between the gray pickup, which was already pulling ahead, accelerating away, and a minivan 4 car lengths forward. She navigated through the gap and onto the right shoulder at 40 miles per hour. She came to rest against the concrete barrier without making contact. Her hands were steady on the wheel. Her heart rate was elevated. She sat for 11 seconds. The gray pickup was gone. A different make and model of vehicle than any she had documented before. She called roadside assistance. While she waited for the response, she photographed the tire valve stem from 4 angles, documenting the deflation pattern and the specific damage characteristics around the valve. She called Priya. "Not an accident," she said when Priya picked up. "Document everything before anything is touched," Priya said. Then APD. "Already documenting." She crouched beside the tire. "The valve stem has been modified. You don't get this pattern from road debris or even from impact. You get it from a precise compromise of the valve mechanism. Someone touched this car before I got in it, and someone in a second vehicle triggered it at the right moment. Sandy. Priya's voice was measured and careful. What you're describing, remotely triggered valve compromise, coordinated vehicle, this is not Reed Calloway. Reed is a hammer. This is something else. I know, Sandy said. They hired someone specific for this. Someone with the right tools. She filed the APD report. The officer wrote it as possible road hazard incident. She did not press the point. It was on record. She had the photographs. She sent both to Priya and to her cloud backup simultaneously. She drove the rented car home. She changed her route. She started keeping a log of vehicles that appeared in her rearview mirror more than once. 3 days later, she found something else. She came home at 9:17 in the evening and found her apartment door unlocked. She had installed a biometric lock the week after the termination. She had enrolled her own fingerprint and no one else's. She had the only physical override key, which had been on her person all day. She stood in the hallway for 2 full seconds. Then she stepped back from the door and called APD. She waited in the hallway until 2 officers arrived. They went in first. Flashlights, rooms cleared in sequence. Nothing was stolen. Nothing was broken. The apartment was almost exactly as she had left it. Almost. The fireproof box in the closet had been moved 3 inches to the left. The notebooks stacked on top of it were in a different order than she had left them. The third moved to the top. Her laptop on the kitchen table was closed at a 90-degree angle. She had left it open at 45. On the kitchen counter, centered with geometric precision, corners aligned with the counter edges, was a printout of Miles Fenwick's LinkedIn post announcing his promotion to Chief Technology Officer at Vance Systems. No note, no name, no extraneous markings of any kind. Just the printout, placed with the particular care of someone who wants their message to be understood as deliberate. We know where you live. We know what you have. We know who betrayed you. Think carefully. She stood in her kitchen with 2 Austin police officers behind her. She looked at the printout for 4 seconds. She picked it up. She put it in the folder. 51 items. They had done all of this. Threatened her in a parking garage, sent lawyers to her door, filed 41 federal pages, had Reed Calloway grab her in a federal building lobby, tampered with her tire on the expressway at speed, broken into her apartment to leave a piece of paper on her counter because they were afraid of what she had, and what she had was still there, in the encrypted hard drive in her bag, in a binary file on a server she maintained independently. In the machine code of a system they were calling their own historic breakthrough, where a sequence of bytes sat in a specific location and looked like nothing, unless you had the key and knew where to look and understood what the machine was telling you. She thanked the officers. She filed the report. She replaced the biometric lock with a model that logged every access attempt with timestamp, environmental data, and alert notification to her phone. She spent the following 2 days doing something she had not allowed herself to do yet. She read every public document related to Sterling Vance's previous companies. Not the press coverage. She'd read enough of that. The regulatory filings, the patent applications, the trademark records, the court cases to the extent they were public, which most of them were not. The ones that had been settled, sealed, dismissed. The names that appeared repeatedly across different companies in different years in the same functional roles. Legal counsel, communications, security. The names that followed Vance from one entity to the next like the frame follows a painting. Harlan Cross's name appeared in 3 previous Vance entities. Britta Voss in 2, Reed Calloway in 1 earlier company that had been dissolved 6 years ago, and there, in the archive staff directory of a predecessor company from 2009 to 2013, as head of IT infrastructure, Miles Fenwick. She had thought Miles was circumstantial. She had thought he was someone who had been at the right company at the right time, who had made an opportunistic calculation when the opportunity presented itself. She had not thought he was placed, but there was his name, years ago, in a Vance-adjacent company, in a role that gave him exactly the kind of systems access he had used 14 months later to study her work and photograph her credentials. He had not been hired because he was talented, though he was. He had been hired because he was already inside the apparatus, because someone had looked at what Sandy had built in Atlanta, had looked at the job posting she would respond to, and had positioned the right piece in the right place 14 months before she walked through the door. She sat with this for a long time. Not with grief. She had given grief its 11 minutes, and that account was closed. With something else. The particular quality of understanding that comes when you realize the scale of what you were up against, and then realize, almost immediately, that the scale doesn't change what you have. It only makes what you have more important. She added the archive staff directory to the folder. 53 items. Then she picked up her phone and dialed the 512 number. It rang twice. I wondered how long. The voice was old, not frail but seasoned, with the patience of a man who has been waiting for something important and has learned, through long practice, that waiting and losing are not the same thing. You're Sandy Wren. Yes. A pause, not hesitation, consideration. I knew your work before I knew your name, he said. The inference architecture, the way the bytecode layers. I recognize the method, because I invented it. He paused. And then I taught it to someone who needed it. You sent the documentation, she said. The security research forum, 3 years ago. Yes. She had thought the contributor was anonymous. She had implemented the technique, adapted it significantly, made it her own in ways that mattered technically. She had not known who had sent it or why. Sterling Vance did this to you, she said, in 2013. Yes. You settled. Confidentiality agreement. Yes. A silence that had 11 years in it. I had the work, I had the dates, I had the documentation, I had everything I thought I needed. A pause. What I didn't have was the signature, she said. Was the signature. His voice was flat and steady, and in its flatness, in its careful steadiness, was everything that 11 years of a specific kind of loss sounds like when it has been held for so long it has become structural. You have what I didn't, if you're willing to use it. I need a forensic expert, she said, someone who can authenticate the bytecode signature in a federal proceeding, someone with standing as an expert witness. I know, he said. I have been that person before, in a different case, against the same man. She absorbed that. Against the same man, not a different version. The same man. Come tomorrow, he said. Early. Bring your notebooks. All of them. The Git logs. The blockchain verification. Everything with a timestamp. He gave her the address. Northwest Austin. One more thing, he said before she could speak. The signature. The specific byte sequence in the compiled output. Can you pull it? Yes. Then we have what we need. A pause. The compiler never lies, Sandy. Metadata, they can alter. Timestamps, they can alter. Server records, file headers, creation dates, all of it, with the right tools and enough time, they can alter. What they cannot alter is the binary output, the machine code itself. Because to change what is embedded in the binary, they would have to recompile the entire architecture. And if they recompile, the system changes. And if the system changes, it is no longer the system they demonstrated to the Senate subcommittee. He paused. It is no longer the product they have been showing to investors. And if the product changes, she said, the valuation changes. Exactly, he said. They are trapped by their own success. The more valuable ARIA becomes, the less they can afford to touch the binary. And the longer the binary exists unchanged, the longer your signature exists inside it. What happened to you? She said. In 2013. Can you tell me the shape of it? A silence. Not reluctance, consideration. The silence of a man deciding how much a question deserves. I built a natural language processing system, he said. 14 months of work. My own architecture, documented, versioned, completely original. I licensed it to a company Vance was running at the time. Not Vance Systems, a predecessor company. The license was for a specific limited application. Within 8 months, they had used it as the foundation for a product they filed patents on. My name on none of them. He paused. I filed suit. We were in discovery for 11 months. They buried me in document requests. They challenged my expert witnesses. They deposed everyone I had ever worked with. And then they offered a settlement, money, a confidentiality agreement, and a clause requiring me to withdraw all claims. The alternative was 3 more years of litigation that they could fund indefinitely, and I could not. She waited. I took the settlement, he said. I could not afford not to. And the confidentiality agreement covers that case, that company, those specific claims. It does not cover my knowledge of how Sterling Vance operates. It does not cover my technical expertise, and it does not cover my willingness to testify as a forensic expert in an unrelated proceeding. A pause. I am 73 days past my oncologist's most conservative estimate for how long I would be functional. I have been waiting for a reason to use that time. She was quiet for a moment. How did you know to watch for me? I have been watching his companies for 11 years, Kai Oduya said. I set up alerts, patent filings, press releases, personnel announcements. When the ARIA announcement came, I pulled the technical documentation they released. I recognized the architecture the same way you would recognize a piece of code you wrote. Not because it was identical to mine, but because it used a method that has a specific fingerprint, a method I invented, a method I taught to exactly one other person, indirectly, through an anonymous forum post. A pause. I started making calls. I found your name. I looked at your publication record. I called 3 times before you were ready. She looked at the 3 missed calls in her log, the number she had stared at and not called for weeks. I wasn't ready, she said. I know, he said. Now you are. She sat at her kitchen table in the October dark, the fireproof box in the closet, the folder with 51 items, the hard drive in her bag, the notebooks stacked beside her thermos. She thought about Clause 11b, perpetual, irrevocable, worldwide. She thought about Britta Voss building frames before pictures existed, about Miles at the coffee shop, fist against brick, back turned, about Reed in the federal building lobby, forearm across her chest, about the gray pickup on Mopac, about the printout on the counter, corners aligned, placed by someone she did not yet know the name of, about a man who had been waiting 11 years for a conversation that was now 12 hours away. If you think this story is already something, we haven't even gotten to the part where Sandy Wren stands in a federal courtroom and watches Sterling Vance's expert witness realize, in real time, that there is a question on the table he cannot answer. Subscribe. Do not go anywhere. She opened her notebook. She wrote the date. She underlined it twice. At the top of a new page, in the careful block letters she had used since she was 9 years old, she wrote, "What they stole and how I can prove it." The list was long. She had been building it, in one form or another, for longer than they knew. Not because she had anticipated this exact moment, but because she was the kind of person who documented, who dated every page and underlined it, who kept 3 pens in a row, blue, black, red, who counted camera angles and wrote down exact words and noticed when a notebook had been moved 3 inches and when a laptop had been closed to 90 degrees from 45. She was the kind of person who left signatures in places that cannot be erased, who had been doing it her whole life, in notebooks, in repositories, in the machine code of a system she had spent 2 years building and 14 months perfecting, and whose name she had never even chosen. They had picked the wrong engineer. She wrote until 2 in the morning. She slept 4 hours. She was up before the sun, thermos filled, notebooks in her bag, 3 pens in her jacket pocket, blue, black, red, driving northwest on 183 as the sky went from gray to orange to the clear specific blue of an Austin morning in late October. She changed direction twice. No one followed. The house was on a cul-de-sac, small, white, a live oak in the front yard, whose roots had lifted the sidewalk on both sides, a tree that had been growing there long before anyone built anything around it and would be growing there long after. A porch light on, though the sun was already visible. She parked. She walked to the door. She knocked twice. The man who answered was 61 years old, with the particular stillness in his face that takes a very long time to learn and cannot be performed. He looked at her for a moment without speaking, not evaluating, not deciding, something closer to recognition, the way you look at someone whose work you have studied for years and whose face you are seeing for the first time. "I've been waiting for you," Kai Oduya said. His voice was quiet and certain. "Longer than you think." She looked past him, through the open door. Inside, a desk covered in printed documents, 2 monitors running side by side, a wall that had been given over entirely to a handwritten timeline. Years of it. Dates and names and case numbers and redacted filings, pinned in rows, connected by red lines, annotated in careful small handwriting she was too far away to read. At the top of the timeline, in block letters that had been written and rewritten until the paper was nearly worn through, Sterling Vance. She stepped inside. She closed the door behind her. The house smelled like strong coffee and printed paper, the specific combination she associated with serious work being done in a small space over a long period of time. The living room had been converted into something between an office and a war room. Filing boxes along one wall, labeled in a handwriting too small to read from the doorway. A printer with a full output tray. Bookshelves with technical texts and legal volumes mixed together without distinction. The library of a man for whom law and technology were not separate subjects, but aspects of the same problem. She looked at the wall with the timeline. Up close, she could read the handwriting. She could see the case numbers. She could see the names of the companies Vance had run before Vance Systems, the dates of their formation and dissolution, the dates of the patent filings that had, in several instances, occurred in a pattern she immediately recognized. A talented engineer joined, worked intensively for a period of 12 to 18 months, and then departed. sometimes quietly, sometimes with the kind of noise that generated legal activity, always with the same outcome. The engineer's name disappeared from the product record. The patent applications went forward under different names. She counted 7 instances, 7 over 17 years. Kai had documented each one. "How long did it take you to build this?" she asked. 11 years, he said. On and off, more on than off. She looked at the timeline, at the red lines connecting different entities, different personnel names, different patent numbers, at the handwritten annotations in their careful small script, at the years of documentation assembled by a man who had been told, in effect, that he did not build what he built, and who had spent the years since making sure that the next person could not be told the same. "You've been building a case," she said. "I've been building a record," he said. "I can't file it. The confidentiality agreement limits what I can do with the 2013 case directly, but I can testify to technical facts in your case. And I can give you everything I've assembled about the pattern, the methodology, the personnel, the timing, as background for your legal team." She turned away from the wall. She looked at him directly. He was older than she had imagined from his voice. Or perhaps it wasn't age. It was the specific quality of a man who has carried a weight for 11 years and has not put it down, but has made a kind of peace with its presence. He had the stillness of someone who has moved beyond the acute phase of loss and arrived somewhere more durable. "Why didn't you find someone sooner?" she asked. 7 instances. You had documentation on 7. The others settled, he said, or withdrew, or couldn't be reached. He paused. 2 I found after the fact. I reached out. They declined. They had their reasons. Fear, exhaustion, the settlement money. You do not judge people for the decisions they make under that kind of sustained pressure. He looked at her. "When I saw the ARIA announcement, and when I found your name, and when I read your publications, I made a judgment that you were different. Not stronger, not braver, just prepared in a particular way for this particular fight." A pause. "I was right." She sat down at the chair beside the desk that he gestured toward. She placed her bag on the floor beside her. She took out the notebooks, all 7 of them, the pre-employment one on top, and stacked them on the desk. She took out the Git log printouts and the blockchain verification documents. She placed them beside the notebooks. He looked at the stack. He sat down across from her. "Start with the pre-employment notebook," he said. "Tell me exactly when you began working on the inference architecture." She opened the notebook. She looked at the first dated entry, 2 years and 4 months ago, her Atlanta apartment, a Tuesday night in June. She had written the date and underlined it twice. She had written, on the first line of the first page, "Real-time contextual inference without retraining. Structural problem in the standard approach. Looking for the leverage point." She turned the notebook to face him. He read the first page. He read the second. His expression did not change. He was the kind of man who had learned to hold his responses until he was certain what he was responding to. "All right," he said after several minutes. He looked up. "All right." She waited. "We have a lot of work to do," he said. "And we need to do it before their discovery motion produces anything that changes the timeline." He stood. He went to the filing boxes and pulled one labeled with a year and a case number. "I have the technical authentication process documented from my own experience with a similar signature system. I know what the court will require. I know what the opposing expert will challenge. We are going to build your case from the binary output up, and by the time we are done, there will not be a technical question their lawyer can ask that we have not already answered." He set the box on the desk. "Can you work through the weekend?" "I can work through the month," she said. He nodded. He poured coffee. He set a cup in front of her. Outside, Austin went on with its business. The live oak in the front yard moved in the morning breeze with the unhurried patience of something that has been growing for 100 years and intends to grow for 100 more. The morning was just beginning, and everything that came next, the forensic authentication, the discovery battles, the federal hearing, the moment a courtroom would see what was embedded in the machine code of a system a billionaire had called his own historic breakthrough, all of it was still ahead. But Sandy Wren was already holding all the pieces. She had been holding them since September, 14 months ago, when she had walked into a building in Austin and organized a desk and written a date and underlined it twice and picked up a blue pen. She had been holding them the whole time, and now, finally, she was not holding them alone. They worked through the weekend. They worked through the weekend after that. Kai had a system. Of course he had a system. 11 years of building one had produced something that was less a process than a second instinct. They started with the binary. He pulled it from the hard drive on Saturday morning with a tool he had written himself, a decompiler that rendered the machine code in a format he could read the way most people read English. He sat in front of his primary monitor, and he was quiet for a long time. "You used a modified alignment offset," he said finally. "Not a question." "Standard ELF header puts the signature adjacent padding at byte offset 0x3f8, she said. "I shifted it by 11 bytes. Not enough to break the binary loader. Enough to move it out of the range any automated cleanup script would target." He looked at her for a moment. "Why 11? "It's the number of pages in the termination agreement," she said. "I didn't know that when I wrote it. I just chose a number that wasn't a power of 2 so it wouldn't read as compiler intentional." He turned back to the screen. She watched him navigate through the hex dump. Not slowly, not with the hesitation of someone reading unfamiliar material, but with the confident speed of someone who has spent a long time in this territory. "There," he said. She looked at the monitor. In the middle of what appeared to be routine padding, in a block of bytes that a forensic cleanup tool would register as alignment data and skip, was a sequence she recognized. She had placed it there. 22 months ago, in her Atlanta apartment, at 11:47 in the evening on a Tuesday in June, with her notebook open beside her keyboard and a blue pen in her hand. The bytes spelled, when decoded through the key she had derived from her own git commit hash, Sandy Grace Wren, June 14, 2022. A 3F91C. Her name, the date, the hash of the first commit in the repository that contained the foundational architecture of ARIA. "Can you extract the full sequence?" she asked. "Already running." He had a second tool open in an adjacent terminal window. "It'll produce a hex dump that I can format for court submission, with the decoding key and a step-by-step explanation of the authentication process that any technically literate judge can follow." "How long for the full declaration?" 2 weeks for a draft I'd be willing to sign," he said. 3 weeks for one I'd stake my professional reputation on, which is what I'll be doing." He paused. "My reputation, such as it is, and whatever time I have left to use it." She looked at him. He had said something similar on the phone, about the oncologist's estimate. She did not ask. He had volunteered nothing more, and she respected the boundary of that. He poured coffee. He went back to work. Outside, the live oak moved in the October breeze. They had a great deal to do. They did it. By the end of the second weekend, Kai had produced the first draft of his forensic declaration. 43 pages, dense and methodical, organized around 3 central arguments. The first, that the byte sequence at offset 0x3f8 plus 11 constituted an intentional signature, not compiler artifact, based on its internal structure and its deviation from standard alignment patterns. The second, that the signature encoded information, specifically Sandy's name, a date, and a git commit hash, that corresponded exactly to documentation in her pre-employment repository. The third, that the signature was computationally impossible to have placed in the binary without access to the original source code at the time of its first compilation, and that the date encoded in the signature preceded Sandy's employment at Vance Systems by 18 months. She read the draft twice. She made 4 technical corrections. He accepted 3 and explained patiently and precisely why the 4th was not an error, but a reflection of a subtlety in the compiler behavior that she had not yet encountered in practice, only in documentation. She accepted his reasoning. She wrote it down. She added it to her understanding of the problem, which was expanding in the way her understanding of problems always expanded, not dramatically, not in a single moment of insight, but by accretion, by the careful addition of one verified fact to another, until the shape of the thing was complete. That was how all of her best work had been built. This work was no different. By week 3, Priya had filed the declaration alongside a motion for summary judgment on the copyright claim. She had also filed, separately, a motion to compel production of Vance Systems' internal communications from the 18 months preceding Sandy's termination. Emails, messaging logs, meeting records, anything that touched the ARIA project or Sandy's employment. Vance Systems' legal team filed a motion to strike Kai's declaration on Daubert grounds, arguing that his methodology was unreliable and that his testimony would not assist the trier of fact. They also filed a motion for protective order on the internal communications, citing trade secret concerns. Priya had expected both motions. She had written her opposition briefs before receiving the motions themselves, based on what she would have filed in their position. "They're running the standard playbook," she told Sandy, over coffee in her office. She had a legal pad covered in notes, and the particular energized quality that Sandy had learned to read, as Priya, finding the situation interesting, rather than merely difficult. Delay, burden, and bury. The Daubert challenge is a nuisance motion. Kai Oduya has been qualified as an expert witness in federal court before. They know it won't succeed. They're filing it to use the hearing as a discovery opportunity to depose him before we want him deposed." She paused. "What they don't know is that Kai is not the kind of witness who gives away anything in a deposition that he hasn't already decided to give." Sandy had spent 3 weeks working with Kai. She knew that was correct. "The protective order is more serious," Priya continued. "If they get it, we don't see the internal emails for another 6 months minimum. Maybe more." She looked at Sandy. "I have a source at the court. Off the record, the judge is skeptical of the trade secret argument. But skeptical and overruled are different things. What do we do in the meantime?" "We filed a FOIA request with the USPTO 14 days ago," Priya said, "for the patent application records on ARIA. Applications, supporting documentation, correspondence with the examining attorney. That material is public record once the application is filed. They can't protective order it." She checked something on her notepad. "We should have the first batch within the next 3 weeks." Sandy wrote the date in her notebook, blue pen. The FOIA materials arrived on a Thursday morning, 41 days after the request. Sandy was at Priya's office when the secure digital delivery came through. Priya's paralegal, a careful and methodical young man named Devon, began organizing the documents by date, while Priya and Sandy sat at the conference room table and waited. The patent application for ARIA, filed by Vance Systems approximately 9 months after Sandy's termination, which was approximately 7 months after she had begun working on the project that would become ARIA, was 218 pages long. The application listed 4 inventors. Sandy's name was not among them. Miles Fenwick's name was second on the list. She looked at the application for a long time, at the signatures, at the dates, at the background of the invention section, which described the technical problem that ARIA solved in language that closely paraphrased the exact language she had used in her first full architecture presentation in February, the one where Harlan Cross had asked who helped her. She put the application in the folder. Over 400 items now. She had stopped counting. Devon had organized the supporting documentation into chronological batches. The third batch, correspondence between Vance Systems Patent Counsel and the USPTO examining attorney, beginning 8 months before Sandy was terminated, was what mattered. "Ms. Wren." Devon placed a single document on the table in front of her with the particular care of someone who has identified something they understand to be important before they are asked to identify it. He had been saying her name like this for 3 weeks. Not Sandy, not Hay. The formal address of someone who has formed an opinion about who they are working for and has decided to act accordingly. "Read the email dated October 15th. She noticed the form of address. She filed it. He did not know she had filed it. She found the email. October 15th was 5 months before Sandy's termination. The email was from Vance Systems' in-house patent counsel to their outside patent firm. The subject line was ARIA IP, Timing Attribution Strategy.
The body of the email was substantially redacted, but the unredacted portions included: "Per SV's direction, the attribution framework needs to be established prior to the departure of," and "the termination timing should be coordinated with the IP filing calendar to ensure clean chain of title before the termination." The termination had been planned 5 months before it happened. The attribution framework, deciding whose name would appear on the patent and whose would not, had been established before she was let go. Priya read the email twice. She set it down. She looked at Sandy. "SV," she said. "Sterling Vance," Sandy said. "Yes." Priya was quiet for a moment. "This doesn't prove copyright infringement on its own,
but it proves premeditation. It proves this was not a routine termination that happened to involve IP questions. This was a plan." She paused. "And it is going to change the tone of every deposition we take from here on." Sandy looked at the redacted portions of the email, the black bars over names and details that someone, at some point in the document review process, had decided she should not see. "What's under the redactions?" she asked. "That," Priya said, "is what our next motion is going to ask the court to decide." 42 days later, on a Tuesday afternoon in November, Sterling Vance appeared before the United States Senate Subcommittee on Innovation, Commerce, and Trade. Sandy watched the live stream on her laptop from her apartment, at her kitchen table, with her notebook open and her blue pen ready. The hearing room was impressive. High ceilings, the weight of institutional authority in the paneled walls, and the raised dais where 6 senators sat with their microphones and their prepared questions. Vance was at the witness table, alone, which was unusual for this kind of appearance. He had declined to bring counsel to the table. It was a calculated choice, a statement that he had nothing to conceal, nothing to qualify, nothing that required legal management. He was very good at it. He spoke for 20 minutes before the questions began, a prepared statement that moved from the technical specifics of ARIA, described in clear, accessible language that would land well with a non-technical audience, to its national security implications, to the importance of American leadership in artificial intelligence, to the role of private innovation in maintaining that leadership. He used the words American and innovation more times than she counted. He named 4 of the 5 engineers who had worked on the project. He did not name the 5th. Then he demonstrated ARIA. Live on a screen visible to the senators and the cameras, he showed the system responding to novel data in real time, adapting its inference model without retraining, making accurate contextual predictions from information it had not been trained on. The senators leaned forward. The cameras captured this. Vance narrated with the steady confidence of a man showing something he has full command of. Sandy looked at the screen in the live stream, at the demo running, at the interface. She paused the video. She looked at the lower right quadrant of the demonstration interface, where a build version number was visible in small text. Build 2.1.0. Compiled March 14th. She had been terminated in February. The system had been compiled in March. The binary demonstrated to the United States Senate was a March build. She opened her terminal. She pulled the build from the hard drive, the one she had taken from level B2 the day she was terminated. Build 2.1.0. March 14th. The same build. They had not recompiled it. There had been no reason to recompile it. The version they were showing the Senate was the version she had last touched. The signature was still in it. She looked at the demo running on the Senate hearing live stream, at the version number in the lower right corner, and she understood something that had been true from the beginning, but that she was only now able to see with full clarity. They could not touch the binary. The more successful ARIA became, the more they demonstrated it, the more they filed patents on it, the more they showed it to senators and investors and journalists, the more trapped they were. Every public demonstration was another timestamp. Every audience was another witness. Every moment they left the binary intact was another moment her signature lived inside it. Kai had been right. The compiler never lies. She unpaused the video. She watched Sterling Vance answer questions with the smooth fluency of a man who believes he is completely safe. She wrote the build version number in her notebook. Date, time, source, blue pen, underlined. If you've been following this and you think you can see where it's going, you're right about some of it, and wrong about the part that matters most. Stay with me. 2 weeks after the Senate hearing, on a gray Thursday morning, Sandy drove to Kai's house for their weekly working session. She took her usual route, surface streets, 2 direction changes, mirrors checked every 30 seconds, nothing following. She was on the cul-de-sac, walking from her car to his front door, when Reed Calloway stepped out from behind the live oak. He had not been there a moment ago. He had come from the side of the house, from the narrow passage between Kai's yard and his neighbor's fence, and he moved with the economy of a man who has been waiting and is done waiting. You should know, he said, that what you're planning to do to this company is going to cost you more than you have. She stopped walking. She assessed, 11 feet between them. The front door 8 feet behind her. The street behind him. No other vehicles she hadn't seen before. No second person visible. You followed me here, she said. I know every place you go, he said. He stepped forward, closed the distance to 7 feet. His hands were at his sides, but his right hand was doing what it always did. The slight flex, the anticipatory tension of someone who has decided the next move involves that hand. I know the lawyer. I know the old man in this house. I know what you think you have. Another step, 5 feet. You don't have enough. The front door opened. Kai Oduya stood in the doorway. He was 61 years old and had been living past his oncologist's estimate for months, and he stood in his doorway in a cardigan and looked at Reed Calloway with the expression of a man who has encountered this species of person before and found them, ultimately, less interesting than they believed themselves to be. This is private property, Kai said. Quiet, factual. You have 15 seconds to leave it before I call the Austin Police Department and advise them that a man fitting your description has been following a party to an active federal lawsuit to my private address. Reed looked at Kai. He looked at Sandy. He did the calculation that such men do, weight of force available versus weight of exposure, and arrived once again at the same conclusion he had arrived at in level B2 and in the federal building lobby. He left. He walked back around the side of the house, and she heard a car engine start on the next street. Kai watched him go. Then he looked at Sandy. "He's escalating," she said. "Or he's scared," Kai said. "Those often look the same." He held the door open. "Come in, we have work." She photographed the side of the house where Reed had stood, the scuff marks in the soil where he had been waiting. She sent the photo to Priya. She documented the time, the location, the exact words, the distance. Inside, Kai had the coffee ready and a new document on his primary monitor. He had been working since 5 in the morning. He was always working since 5 in the morning. She had stopped asking him about the hours. "I found something," he said when she sat down. "In the build logs I requested under the discovery order." She looked at the monitor. He had pulled up a log file. Build records from the Vance Systems development server, produced under the discovery motion that the court had partially granted 3 weeks earlier. "These build logs," he said, pointing to a column of timestamps, "are from the server Decker Hull, cited in his declaration as evidence that ARIA existed before your employment. He argued these commits are real development work from 26 months ago." He pointed to a different column. "These are the creation timestamps on the log files themselves." She looked. The log files had been created 14 months ago, 8 months after Sandy had been terminated. The build logs that Hull had cited as proof of pre-employment development had been created, not committed, not generated, created, 8 months after the termination. "They're fabricated," she said. "The log files were generated by a script that produced plausible-looking commit records with historical timestamps," Kai said. "But the script left a fingerprint. The entropy pattern in the timestamp distribution is non-random. It follows the output pattern of a specific timestamp generation library." He paused. "A library that was released open source 11 months ago, after the events they supposedly document." She looked at him. "Decker Hull either made this himself or was given this by someone who did," Kai said. "Either way, he submitted it to a federal court as evidence. That is perjury in a federal proceeding, under 18 U.S.C. section 1621. She wrote the statute in her notebook, black pen. The discovery battle produced its first significant result 6 weeks later. The court granted Priya's motion to compel production of the internal communications, partially. Vance Systems had to produce emails related to Sandy's employment and termination from a 90-day window around the termination date, with redactions permitted only for genuinely privileged attorney-client communications. The trade secret protective order was denied. The emails arrived in a production of 1,200 pages. Devon spent 2 days organizing them. On the 3rd day, he came into Priya's conference room where Sandy had been reading through the batch and placed a single printed email on the table in front of her. "I think this is important," he said. He was careful, Devon, careful and precise, and the kind of person who did not interrupt unless the interruption was warranted. The email was dated 3 days before Sandy's termination. It was from Miles Fenwick to an internal distribution list of 11 recipients. The subject line redacted. The body was substantially redacted. The unredacted portions read, "The termination is confirmed for Wednesday. The 61-hour window has been tracked and confirmed." And, "The agreement will be placed for signature at 4 p.m., per HC's recommendation regarding timing." H.C. Harlan Cross, the 61-hour window. They had tracked it. They had been watching how long she had been awake. They had known exactly when she was most vulnerable to signing a document she had not fully read. She sat with this for a long time. Not with grief. With something that had moved well past grief into a territory that had no common name. The particular quality of understanding what had been done to you in full technical detail, with evidence, with timestamps, with the initials of the person who had recommended the exact hour. She put the email in the folder. She did not say anything. Devon refilled her coffee without being asked. The deposition of Decker Hull took place on a Friday morning in February, in a conference room on the 14th floor of a law firm in downtown Austin. Hull arrived with 2 attorneys from Vance's legal team. He was professionally composed, precisely dressed, and carried himself with the calibrated confidence of a man who has testified before and knows how to do it. Priya had prepared for this deposition for 3 weeks. She had Kai's analysis of the fabricated build logs. She had the entropy pattern report. She had a forensic expert of her own, not Kai, whose testimony they were preserving for a different context, to speak to the technical methodology. She did not use the bomb immediately. She spent 90 minutes on Hull's background, his methodology, the sources for his declaration, the specific data sets he had relied on. Hull answered every question smoothly and professionally. He had a good answer for everything. Then Priya placed a single document on the table in front of him. She placed it face down first and left it there for a moment. "Mr. Hull," she said, "the build logs you cited in your declaration, exhibits G through K, You represented those as contemporaneous records from the Vance Systems development server, created at the time the builds they document were compiled. That is what they are, Hull said. She turned the document over. This is a forensic analysis of the entropy distribution of the timestamp fields in those log files. The analysis concludes that the timestamp generation pattern matches the output signature of an open-source timestamp library, specifically a library that was first publicly released 11 months after the most recent of the events those logs claim to document. A pause. Short, 1 second, 2. Hull's attorneys exchanged a look that was not quite visible to anyone watching casually, but Sandy caught it. She was very good at catching things. I'm not familiar with that analysis, Hull said. His voice was the same. His hands, on the table in front of him, had changed slightly. That's understandable, Priya said. You submitted your declaration 6 months ago. You may not have anticipated this particular line of inquiry. She placed a second document beside the first. This is the public release record for the library in question. Release date confirmed. She placed a third. And this is the specific method call in the library's API that produces the entropy pattern documented in the analysis. Hull looked at the 3 documents. He looked at Priya. I would need time to review this, he said. His voice was still controlled. But something beneath the control had shifted. A micro-movement in the precision of his composure, the specific quality of a man who has been very good at something for a very long time, and is discovering that good is not the same as unassailable. Of course, Priya said. We'll recess for 15 minutes. She did not need the 15 minutes. She had made her point, and she was willing to let it sit, while Hull's lawyers spoke to him in a corner of the room in voices too low to be recorded. 3 days after the Hull deposition, Sandy walked out of the federal building parking structure at 7:45 in the evening and found her rental car sitting on its rims. All 4 tires, slashed clean through the sidewall. Not vandalism, not road damage. Each cut made with a single deliberate stroke of something designed to cut rubber, not tear it. The cuts were at identical heights on each tire. The parking structure camera on that level, she noted, had been taped over. A strip of black electrical tape across the lens, placed carefully enough that it would not be visible from any camera angle in the neighboring stalls. She stood and looked at the tires for a moment. She took photographs of each tire, the cut pattern, the tape on the camera lens. She called Priya. She called APD. She called the rental car company. While she waited for the tow truck, a man in a gray jacket walked past the entrance to the parking level at the far end of the structure. He did not stop. He did not look at her. He walked at the measured pace of someone who is not in a hurry, because they do not need to be in a hurry. He turned the corner and was gone. She had seen that jacket twice before. Once outside the federal building, the day Reed Calloway shoved her against the marble wall. Once in the background of a photograph she had taken of the gray pickup's license plate on Mopac Expressway. She looked at the corner where the man had disappeared. She memorized the particulars: height, gait, the slight outward turn of the left foot when walking. She wrote them in her notebook while she waited. Date, time, location, description. She had Devin run the jacket color against every background detail of every photograph she had taken since the termination. He found 17 matches across 11 photographs. The same jacket, or one identical to it. Behind her car in 3 locations. In the background of a photo she had taken outside Priya's office. Outside the coffee shop where she had confronted Miles. Whoever this is, Devin told her on the phone that evening, they've been following you since at least 8 days after your termination. Possibly longer. I know, she said. His name is Andrew Reese. She had found the name 3 weeks earlier in the Delaware incorporation records for the consulting firm that appeared in a wire transfer that Priya's forensic accountant had traced from a Vance Systems vendor payment account. A firm with 1 registered agent, no physical address, and a single active contract with Vance Systems beginning the week after Sandy's termination. Andrew Reese, 44 years old, former private security for 3 technology companies whose litigation histories, when she charted them, shared a pattern she recognized. She sent the name and the jacket photographs and the wire transfer record to Priya. This is 18 U.S.C. section 1512, Priya said when she called back. Witness tampering and obstruction of a federal proceeding. This is not a civil matter. I know, Sandy said. I want you to send it to the U.S. Attorney's Office. A pause. That's a separate track. Civil and criminal proceedings simultaneously. It complicates things. I know, Sandy said. I want it complicated. The Daubert hearing on Kai Oduya's qualifications as an expert witness was scheduled for a Monday morning in March. Sandy drove to the courthouse. She found her rental car, the replacement, the second replacement, since the first replacement's tires had also been interfered with, intact in the courthouse parking lot. She walked to the courthouse entrance. On the steps, a man she did not recognize fell into step beside her on the right. He was close enough that their shoulders touched. He did not look at her. He reached out, quick, deliberate, 2 fingers on her wrist, not gripping but pressing, the precise amount of pressure that communicates knowledge of where a nerve runs and willingness to use it. And he said, in a voice so low it was less sound than texture, "Drop the case, last time." Then he was past her and moving away, down the steps and around the corner, gone in the time it took her to turn fully. She stood on the courthouse steps for 3 full seconds. Her wrist was fine. The pressure had not been damage. It had been information. She was still collecting information. She wrote the time and the exact words and the exact location of the pressure in her notebook. She flexed her fingers once to confirm full sensation and continued into the building. If you're still here, good. Because what happens in the next 20 minutes of this story is the part that no one in that courthouse was prepared for. Not Vance's lawyers, not Hull, not even Priya. Kai Oduya was already in the hallway when she arrived. He was seated on the wooden bench outside the courtroom, his briefcase beside him, his hands folded on his knees with the particular stillness that was simply how he occupied space. He looked up when she approached. "Ready," he said. She sat beside him. She looked at him, at the stillness, at the quality of patience in his face that she had come to understand was not resignation, but its precise opposite. He had been waiting 11 years for a specific moment in a specific kind of room, and the room was 30 feet away and the moment was coming. "How are you?" she asked. She asked because she was asking about his health, which she rarely asked about directly, and she was asking because she needed to know. "Functional," he said. "I will be functional through what I need to be functional for." That was the answer. She accepted it. Vance's lead attorney, a woman named Theron, senior partner, 58 years old, with the kind of courtroom presence that comes from 3 decades of building it, had filed the Dober challenge arguing that Kai's methodology was not sufficiently peer-reviewed and that his testimony would not assist the trier of fact. It was a standard challenge. It was the kind of challenge that experienced expert witnesses expect and prepare for. Kai had been an expert witness in federal court 4 times before the 2013 Vance case. His methodology paper on bytecode analysis had been cited in 14 subsequent technical publications. His qualifications in binary-level forensics were, as Priya's opposition brief had argued in considerable detail, extensive. Judge Margaret Osei, Western District of Texas, appointed 8 years ago, known among practitioners for a particular intolerance for delay tactics and a technical fluency that surprised attorneys who expected a generalist, reviewed the briefs and the supporting documentation, and made her ruling in 22 minutes. Sustained. Kai Oduya was qualified as an expert witness. Theron did not react visibly. She wrote something on her legal pad. Vance's second chair attorney, a younger man whose name Sandy did not know, looked at the pad and then at Theron and did not look at anything else for a moment. The trial date was set for the following September. 6 months away. 6 months in which everything would be built. The trial did not begin in September. In August, 2 things happened. The first, the U.S. Attorney's Office, which had been reviewing the Rice materials for 4 months, announced the convening of a federal grand jury. The investigation was described in the public notice as related to potential obstruction of civil proceedings in the Western District of Texas. No names were named in the public notice. No names needed to be. The second, Miles Fenwick retained his own attorney, separately from the Vance Systems legal team, a fact that Priya's investigator discovered because Miles filed the engagement letter with a bar association form, and bar association forms are public record. A defendant who retains their own counsel is a defendant who has decided their interests may not be aligned with the people who employed them. Sandy heard this from Priya on a Tuesday afternoon in August. She was at her kitchen table, a fresh notebook open, the thermos to her right, 3 pens in a row. She was 35 years old now. The notebook was the 12th she had filled since September 2 years earlier. "What does that mean?" she asked, though she already knew. "It means Miles Fenwick is talking to his own lawyer about what kind of exposure he has," Priya said, "and his lawyer is talking to the federal prosecutor about what kind of cooperation might reduce that exposure." A pause. "It means the grand jury subpoenaed him, and he knows the answer to what they're going to ask, and he knows that if he lies to a grand jury, he's looking at perjury on top of everything else." Sandy wrote in her notebook, date, time. "He's going to talk," she said. "I believe so," Priya said. "Yes." The trial began in October, pushed back 1 month from the original September date by a motion Priya had filed to incorporate the grand jury investigation as relevant context. The motion was granted. Judge O.C. was not the kind of judge who allowed cases to proceed in artificial isolation from directly relevant parallel proceedings. The courtroom in the federal building was large enough to matter, small enough to feel the pressure in it. Sandy sat at the plaintiff's table in a dark blue suit she had bought for this purpose, a notebook in front of her and 3 pens beside it, and she watched the room fill. Priya to her left. Their forensic accounting expert, a woman named Chandris, at the far left. Kai Oduya seated in the second row of the gallery, the witness section, because he would not testify until the 3rd day of trial, and until then he was simply a man in a cardigan on a bench. Sterling Vance sat at the defendant's table in an Italian suit that communicated what it was designed to communicate. Theron beside him, Hull behind the bar in the gallery, available for consultation. Britta Voss was not in the courtroom. Reed Calloway was not in the courtroom. His absence was, in its own way, a communication. Harlan Cross was there. He sat in the gallery in the row, directly behind Vance's table, his hands folded, his expression the one he had worn at the architecture review in February 2 years ago, the expression of a man maintaining composure in the face of information that conflicts with his prior categorization. The opening statements took the morning. Theron went first. She was very good. She built, in 40 minutes of precise and credible argument, a version of events in which ARIA had been conceived by a team, developed by a team, owned by the company that had funded and supported that team, and in which Sandy Wren's claims were the sincere but ultimately mistaken assertions of a talented engineer who had conflated her contribution with the whole. She did not call Sandy unstable. She did not use Britta Voss's language. She was more careful than that. She used words like contribution and collaboration and the natural complexity of team-based innovation. She cited Decker Hull's declaration 3 times, though she did not mention that Hull had stopped returning her calls since the deposition. What Theron was very good at, what made her the kind of attorney who billed at the rates she billed at, was the management of emphasis. She spent 12 of her 40 minutes on the question of Sandy's pre-employment repository, which she described as personal experimental work that had informed but not constituted the ARIA system. She spent 8 minutes on the IP assignment clause, arguing that Sandy, as a senior engineer with a graduate degree, had signed a document she was capable of understanding. She did not mention the 61-hour window. She did not mention the 5 in the afternoon timing. She did not mention the October email with the phrase, "The 61-hour window has been tracked and confirmed." Priya would mention those things. That was for later. Harlan Cross, in the gallery, listened to Theron's opening with the expression he maintained in meeting rooms: polite attention, authoritative neutrality. He had written months ago his trade journal column about the importance of protecting innovation from disgruntled talent. The column was part of the court record, introduced by Priya as evidence of the coordinated narrative campaign. Cross had read, in a pretrial deposition, the specific paragraph of the column in which a hypothetical scenario bore specific resemblance to facts that had not yet been made public at the time of writing. He had been asked, under oath, how the hypothetical in his column matched the specific facts of a then undisclosed dispute. He had said coincidence 4 times in different formulations. The word coincidence had appeared in Priya's trial brief 8 times, always in the context of something it did not explain. Priya went second. She was more direct. She took 31 minutes. She described, without embellishment, what had happened. The pre-employment development, documented and time-stamped. The 14 months of employment during which the architecture was refined. The termination timed to the 61st hour of sleep deprivation. The agreement signed with the specific clause buried on page 5. The public relations campaign that preceded any public claim. The wire transfers to Andrew Rice. The fabricated build logs and Decker Hull's declaration. Then she said, without theatrical emphasis, "The defense will not be able to explain one thing, a sequence of bytes embedded in the compiled binary of ARIA's core module. Bytes that encode, in a format we will demonstrate to this court, the plaintiff's full name, a date, and a git commit hash that corresponds exactly to development work she performed 18 months before her employment at Vance Systems began. That sequence of bytes exists in the version of ARIA that Mr. Vance demonstrated before the United States Senate. It exists in the current production build. It exists because the plaintiff put it there, and because to remove it, the defendant would have to destroy the product." She paused. "They have not removed it, because they cannot." The room was quiet for a moment. Judge O.C. said, "We'll break for lunch." Kai Oduya took the stand on the 3rd day. He was 61 years old. He was wearing the same cardigan he wore every day in his home office. He had a leather notebook and a ballpoint pen that he placed on the railing of the witness box when he sat down. He looked at Priya when she began her examination, and he answered every question with the focused economy of a man who has been thinking about these specific answers for a very long time. She started with his qualifications. She walked through his academic background, his technical publications, his expert witness history. Theron objected twice. Both objections were overruled. Kai answered each question precisely and completely, and did not provide more information than was asked for. A discipline Sandy had learned in 3 weeks of working with him that was harder than it appeared. Then Priya moved to the methodology. "Mr. Oduya," she said, "can you describe in general terms what you found when you examined the binary output of ARIA's core inference module?" He described it. He used the language of his declaration, clear, technical, precise, but he translated it as he went, finding the English for each technical concept that made it accessible without making it imprecise. He described the ELF header structure. He described standard compiler alignment behavior. He described the deviation from that behavior at byte offset 0x3f8 plus 11 and what the deviation indicated, that the bytes in that location had been placed deliberately, not generated by a compiler. "And what did those bytes, when decoded, produce?" Priya asked. He said, "A name, a date, a git commit hash." "What name?" "Sandy Grace Wren." "What date?" "June 14th, 2022. "And the git commit hash, were you able to verify what it corresponds to?" "Yes." He opened his leather notebook. "The hash corresponds to commit a 3F91C in a Git repository that the plaintiff has produced in discovery. That repository contains the foundational architecture of the adaptive inference method that forms the core of ARIA. The repository was created on June 8, 2022. The commit referenced in the signature was made on June 14, 2022. The plaintiff was not employed by Vance Systems until 14 months later. The courtroom was quiet, not the dramatic quiet of a movie, the particular quiet of a room full of people updating their understanding of something important. Judge Osei was writing. Sandy watched her write without appearing to watch. Theron's cross-examination took 90 minutes. She was thorough and technically competent and asked every question Sandy had anticipated she would ask. She challenged the uniqueness of the encoding method. She challenged the assertion that the bytes could not have been placed by a compiler artifact. She challenged the chain of custody for the binary used in the analysis. Kai answered every question. He had no answer he had not already given in the declaration. He had no gap in his methodology that could be exploited. Theron was a very skilled attorney, and she found nothing. At one point she asked, "Mr. Oduya, is it possible, even theoretically, that the byte sequence you've identified could have been generated by coincidence, by random compiler output that happened to encode, in the format you've described, a name and a date?" He looked at her. "The probability," he said, "of a random process generating a sequence that decodes to a specific full name, a specific date, and a specific valid git commit hash in the correct format and at the correct location is approximately 10 to the negative 47th power." He paused. "If you would like me to show my work on that calculation, I have it here." She did not ask him to show his work. He was excused at 2:47 in the afternoon. He walked past the plaintiff's table on his way back to the gallery. He did not look at Sandy. He did not nod. He sat down on the bench, placed his leather notebook in his lap, and folded his hands. She looked at him for 1 second. Then she looked forward. Decker Hall withdrew from the case on the 4th day of trial. He did not testify. His attorneys, who were not Vance's attorneys, he had retained his own counsel 3 weeks after the deposition, in circumstances that paralleled Miles Fenwick's decision, sent a letter to the court stating that Hull would invoke his Fifth Amendment right against self-incrimination if called to testify. The letter was filed at 7 in the morning. By 9, when court resumed, every attorney in the room knew what it meant. A witness who takes the Fifth in a civil trial cannot be compelled to testify. But the jury, and in this case the judge, since they had agreed to a bench trial, is permitted to draw adverse inference from the invocation. Theron requested a brief recess. It lasted 40 minutes. When court resumed, she announced that the defense would not be calling certain previously disclosed witnesses and would be limiting its expert testimony. Hull's fabricated build logs, the exhibits G through K from his declaration, were stricken from the record by joint stipulation after the entropy analysis was entered into evidence and the defense declined to contest it. Miles Fenwick appeared before the grand jury on a Wednesday in November. He was there for 4 hours. His cooperation agreement, negotiated by his attorney over the preceding 6 weeks, required his truthful testimony in exchange for a recommendation of reduced sentencing. He was being charged with 1 count of computer fraud under 18 U.S.C. Section 1030 for the unauthorized access of Sandy's GIT credentials, and with 1 count of making material misstatements in connection with a federal proceeding. She was not in the grand jury room. She was in Priya's office, reading through a motion draft, when Devon knocked on the door and said that Priya's contact at the court had sent a message. He was testifying. She put down the motion draft. She picked up her blue pen. She wrote the date in her notebook. She underlined it twice. What Miles Fenwick said in that room, the specific language of his testimony, the precise sequence of events he described, became part of the sealed grand jury record. What emerged from the room, through the cooperation agreement and the subsequent indictment documents, was this. Miles Fenwick had been pre-positioned at Vance Systems by arrangement with Sterling Vance's internal organization as early as 2019. His role was to build relationships with the technical team, specifically to identify high-value independent work being brought into the company by new hires, and to ensure that the company had access to that work through legitimate means, employment agreements, IP assignment clauses, or, if necessary, other means. He had photographed Sandy's temporary Git credential from her desk during the August server migration. He had transferred the credential to Reed Calloway, who had transferred it to a Vance Systems server administrator, who had used it to access her personal repository and document its contents. The documentation had been used to prepare Decker Hull's fabricated build logs. In exchange for this work, Miles Fenwick had been given the Chief Technology Officer title. The title had been promised to him 9 months before Sandy's termination. The LinkedIn announcement had been posted one day after the termination because that was when the arrangement became operative, not because Vance had spontaneously decided he deserved a promotion. Miles Fenwick had known the plan. He had participated in the plan. He had made a calculation, and the calculation had been wrong, and now he was in a federal building explaining it to a grand jury. Sandy read the summary of his cooperation agreement. She wrote nothing in her notebook for a long time. She thought about the November night. The floor beside the server rack. The coffee at 2 in the morning. We always fix it. Then she wrote the date and underlined it twice and turned to the next page. Judge Margaret Osei delivered her findings on a Thursday morning in December. The courtroom was full. Sandy sat at the plaintiff's table in the same dark blue suit. Priya was to her left. Kai Oduya was in the second row of the gallery, in his cardigan, with his leather notebook. The next 2 minutes are the reason this story exists. Don't stop reading. The judge's findings ran to 61 pages, which Devon had obtained and began printing the moment the electronic filing appeared in the court system. The summary of conclusions was read aloud by Judge Osei in the measured cadence of a person who does not believe that important things should be rushed. Copyright infringement under 17 U.S.C. Section 501, found in favor of the plaintiff. The signature evidence, in combination with the pre-employment JIT repository and the corroborating notebook documentation, established Sandy Wren as the author of the core inference architecture of ARIA. The patent application filed by Vance Systems listing other inventors was ordered to be corrected within 90 days to include Sandy Wren as a named inventor. Clause 11(b) of the termination agreement, void and unenforceable. The court found that the agreement had been procured through fraudulent inducement, specifically that Vance Systems had planned the termination timing, had monitored the plaintiff's sleep deprivation, had deliberately scheduled the signing at a moment calculated to impair her ability to review the document, and had embedded the critical IP assignment clause on page 5 in language designed to appear routine. Under Texas common law and the Restatement Second of Contracts, Section 164, the court held that a party who induces assent through fraudulent concealment of a material term cannot enforce that term. The IP assignment in Clause 11(b), perpetual, irrevocable, worldwide, was severed from the agreement and declared unenforceable. Sandy Wren retained full ownership of the architecture she had created. Damages. The court ordered the parties into a 90-day mediation process to determine appropriate compensation. The court's preliminary finding was that damages were substantial and that Vance Systems would be required to either license the technology from Sandy Wren going forward or cease using it. She sat and listened to the findings read aloud. She was very still. She had learned stillness from Kai, or perhaps she had always had it and recognized it in him. Or perhaps stillness is simply what you become when you have been carrying something very heavy for a very long time, and it is finally set down. When Judge Osei concluded the summary and called a recess, Priya put her hand on Sandy's arm. Briefly, firmly, the gesture of a woman who does not do this often and is doing it now because it is warranted. That's the ruling, Priya said. That's what we built. Sandy looked at the table. She looked at her notebook, open to the current page and the blue pen beside it. She looked at the date she had written at the top of the page that morning, underlined twice. Thank you, she said. Priya nodded once. In the gallery behind them, Harlan Cross stood and put on his coat and left the courtroom without speaking to anyone. Sterling Vance sat at the defendant's table for 4 minutes after the recess was called. Theron spoke to him in a low voice. He listened. His face was doing the thing that faces do when a man who has spent 52 years being correct about the distribution of power in any room he enters discovers that he was wrong about this one. He stood, he left. He did not look at Sandy. In January, 2 months after the verdict, Andrew Rice was indicted by the federal grand jury on 3 counts of obstruction of a federal proceeding under 18 U.S.C. Section 1512. The specific acts cited in the indictment were tampering with the plaintiff's vehicle through remote activation of a compromised valve stem assembly on Mopac Expressway, unauthorized access of the plaintiff's residence resulting in the disturbance of evidence and the placement of materials designed to intimidate a witness, and the engagement of a third party, named in a sealed supplement, to make a verbal threat to the plaintiff on the steps of the federal courthouse. The gray jacket on the courthouse steps. She had been right about the timing of it, the precision of it. The man who had fallen into step beside her was not Andrew Reese himself. He was the subcontractor Reese had used for the Mopac coordination. The name was in the sealed supplement. It would not be public for some time. Reed Calloway was placed on administrative leave from Vance Systems, pending the investigation into his role in coordinating the surveillance of Sandy and in the incident at the Austin Federal Building. He was not yet charged. Administrative leave was not punishment. Administrative leave was the first position in a series of positions that institutions occupy when they are protecting themselves while deciding how much of an individual employee they can afford to sacrifice. Whether charges would follow was, as of the date she read the announcement, pending review. The union representing building security personnel had already engaged counsel on his behalf. The union lawyer had already used the phrase isolated incident in a statement to a local news outlet. The statement had described Reed Calloway as a dedicated security professional with a 17-year record and characterized the incident at the federal building as the result of communication difficulties during a complex and emotionally charged situation. She read the statement twice. She added it to the folder. Britta Voss had not been named in any of the criminal proceedings. She had not been deposed in the civil case. Priya had subpoenaed her, but a motion to quash had been partially granted on grounds that most of her communications were protected by PR client privilege, which was not a recognized legal protection, but which had bought enough procedural delay that the trial had concluded before the issue was resolved. The Vance Systems legal team had offered, as part of the mediation discussions, to include Britta Voss in a broader settlement that covered the defamation claims arising from her unstable narrative campaign. The offer was for a lump sum, with a non-disparagement clause running in both directions. Sandy had accepted the financial portion and declined the non-disparagement clause. Britta's attorneys had pushed back for 2 weeks. Then they had accepted. The financial portion was finalized. Britta Voss remained at Vance Systems, unchanged in her title, unchanged in her responsibilities, changed in some way that was difficult to quantify, but that Sandy registered the one time, 6 months after the settlement, when she encountered Britta's name in an industry publication. The article quoted her. She had said nothing about Sandy Wren. The Department of Justice issued a statement indicating that a preliminary review had been opened into potential patterns of intellectual property fraud at Vance Systems and its predecessor entities. The statement used the words preliminary and potential and review. It did not use the word indictment. It did not use the word criminal. It was the beginning of something, not the thing itself. The mediation process between Sandy and Vance Systems, required by the court's order, began in February. Sandy was represented by Priya. She was not present for the first 3 sessions. She was present for the 4th. She sat across the table from Vance's attorneys, not from Vance himself, who did not attend, and she listened to the numbers they proposed. She listened carefully. She did not accept the first number or the second. She accepted a number in the 3rd session. The settlement amount was not disclosed publicly by mutual agreement, which was one of the conditions she had agreed to. She had not agreed to a non-disparagement clause. She had not agreed to any restriction on speaking publicly about what had happened. Those conditions had been proposed. She had declined them. The case had a public record. The court findings were public. The grand jury indictments were public. She did not need a condition about public speech in the settlement agreement because the public record already said everything that needed to be said. Kai Oduya went back to Northwest Austin. He went back to his house with the live oak in the front yard and the timeline on the wall and the filing boxes labeled in small, careful handwriting. His oncologist, when he saw him in February, noted that he was, characteristically, given the 11-year history of Kai being characteristically imprecise about medical categories, still here. That was the assessment. Still here. He was working on something. He did not say what. She did not ask. She visited on a Saturday morning in March. She brought coffee from a place on South Lamar that he had mentioned once, offhandedly, as making coffee that did not require apology. She knocked twice. He opened the door with the same expression of recognition that was simply how he looked at her now. Not because they had become close in the dramatic sense, but because they had been in a specific kind of room together, and that leaves a specific kind of mark. They sat at his desk. He was working. She had brought her current notebook, the 13th, and she worked beside him, which was something she could do now without explaining. Two people who worked best in the quiet, on opposite sides of a desk. After 90 minutes, not 1 hour as she had planned, because she had underestimated how much she was not yet done needing this particular quality of quiet, she looked up from her notebook and looked at the timeline wall. She had looked at the timeline wall many times. On the first morning, it had been overwhelming in scale. She had counted 7 engineers, 7 instances. In the months since, she had learned the pattern of each: the recruitment, the productive period, the methodical extraction, the departure. Each with its own personnel names, its own documents, its own ending. The ending of each was different in its particulars, same in its structure. "Do you think about the ones who settled?" she asked. "The ones who couldn't fight it?" He considered the question carefully. She had learned that he always considered questions carefully before answering them. "Yes," he said. "Less than I used to." She waited. "What I think about now," he said, "is whether the record I built made their outcome easier to live with, whether knowing that someone documented it, that someone kept the evidence even after they were gone, gave them something to hold on to." He paused. "I don't know if it did. I know it gave me something." She looked at the timeline, at the names, at the red lines connecting them. "It gave me something too," she said. He nodded. He went back to work. She went back to her notebook. The coffee was very good. Outside, Austin went on with its business. The live oak moved in the March wind. After an hour, he said, "The DOJ review." "Yes. If it goes forward, if they find evidence of a pattern, they'll need the 2013 material, the documentation I built." He looked at the wall, the timeline wall, with its red lines and its handwritten annotations and Sterling Vance at the top. "The confidentiality agreement covers the case. It does not cover providing the documentation to a federal investigation. There is precedent for that distinction." She looked at him. "I've spoken to an attorney about it," he said. "The Department of Justice can subpoena the records. If they subpoena them, I am required to produce them regardless of the confidentiality agreement." He paused. "I have been told, informally, by the kind of person who delivers informal information in contexts like this, that a subpoena is being prepared." She wrote something in her notebook. She underlined it. Red pen. "The 7 engineers," she said. "The 7 over 17 years." "Yes," he said. "If the DOJ has the full pattern." "Then what happened to you is not 1 case," Kai said. "It is 8. And the methodology that produced 8 cases over 17 years is the kind of thing a federal investigation takes seriously." He paused. "Whether it results in criminal charges, or a civil consent decree, or a structured settlement, or something else, that depends on factors I cannot predict and you cannot control. The system moves slowly. The system protects itself. What we can control is what we give it to work with." She closed her notebook. She picked up her coffee. Outside the window, the live oak moved in the March wind with the patient, unhurried motion of something that has been growing for 100 years and is not in a hurry. She moved in April. Not far. Still Austin. Still on the east side, but a different apartment, larger, with a second bedroom she converted into a workspace. She bought a new desk. She organized it on her first morning before touching anything else. Laptop, upper left corner. Thermos to the right. Notebook, new, black, hardcover, college-ruled, open flat beside the keyboard. 3 pens in a row, blue, black, red. She wrote the date at the top of the first page and underlined it twice. She had been approached, in the month since the verdict, by 3 companies and 1 academic institution. All 4 were legitimate. All 4 had read the court documents. 2 of them had read her publications. One of the 3 companies, a machine learning research firm based in Seattle, had sent a letter, not an email, written on heavy cream paper that began, "We are aware of what you built. We know what you built because we have studied your pre-employment repository and your pre-trial declaration and the judge's findings. We would like to understand if you might be interested in building something new, at your own pace, with full ownership of what you produce." She had read the letter 3 times. She had put it in the folder. The folder was full. She had started a second one. In the months between the verdict in December and the move in April, She had done a number of things that did not appear in any legal document and would not appear in any future coverage of the case. She had called her mother in Decatur, Georgia, and explained what had happened. Her mother, a mathematics teacher who had spent 30 years finding problems interesting rather than threatening, had listened for 40 minutes without interrupting. Then she had said, "I always knew you were right. I didn't know it would take this long." Sandy had written the date in her notebook afterward, but she had not written her mother's words. She did not need to write them. Some things you keep without paper. She had gone to a park near her old apartment. She had sat on a bench for 1 hour with nothing, no notebook, no phone, no pen, and watched the trees move in the February wind. She was not in the habit of doing this. She did it once. It was enough. During that hour, she had been thinking about something she had not yet found language for, the fact that certain things can be simultaneously true, that the work she had done in those 14 months was good, and that it had been taken from her, that the friendship she had with Miles during those 3 a.m. hours had been real, and that it had been used against her, that the being real of both the work and the friendship was not cancelled by the taking and the using. The taking and the using were their own facts. The work and the friendship were theirs. She had gone home and written this in her notebook. She had underlined it twice. Blue pen. Then she had gone back to the problem on the previous page, the new architecture, the new problem, and kept working. She was working on something new. She had been working on it since October, in the margins of the trial, in the hours before and after. It was a different problem from ARIA. More difficult, more interesting. She had not named it. She had only the first notebook, the first 15 pages of careful documentation, the problem statement on the first line underlined twice. The Git repository was initialized. The first commit was timestamped, hash verified, and signed. Not in the metadata, deeper than that. She had put the date in the machine itself, where no one could reach it. She always did. 2 things remained unresolved and would remain so, at least for now. The email from the October 15th production, the one from Miles Fenwick to the distribution list of 11 recipients, had a subject line that had been redacted in the initial production. Priya had filed a motion to compel unredacted production of the subject line on the grounds that the redaction was not covered by any legitimate privilege claim. The court had ordered production. The produced version of the email had the same redaction. Vance Systems counsel filed a declaration stating that the original email file had become unavailable during a server migration conducted 2 months earlier. The migration had occurred 3 weeks after the grand jury convened. The subject line of that email and the identities of its 11 recipients, 7 of whom remained unaccounted for in any other document, remained unknown. The building security footage from the Austin Federal Building on the day Reed Calloway shoved Sandy against the marble wall showed, on the camera covering the elevator bank, a clear recording of the incident from 8 seconds before his approach to 4 seconds after her phone rose. The footage then skipped. 10 minutes of recording, gone. A clean cut, not a malfunction. The specific gap of something excised rather than lost. The marshal who had responded had filed his report. Sandy's photo existed. The recording that would have corroborated the full sequence of events from Reed Calloway's entry to his departure was 10 minutes of missing footage in a camera system maintained by a contractor whose subcontract with the federal building had been renewed, the previous November, by a board of review that included one person whose name had appeared in a Vance Systems vendor payment record. The connection was indirect. It was speculative. It was the kind of thread that, pulled carefully, might yield something, or might yield nothing, which would also be a kind of information. Priya had pulled it. She was still pulling. On a Tuesday morning in April, 9 days after she had organized her new desk and written the date at the top of the first page of a new notebook, Sandy's phone showed a notification from a professional network she still maintained, though she rarely used it. She opened it. Someone had tagged a job posting in her notifications. The posting was from a company she did not recognize, a small machine learning startup incorporated 4 months ago, operating out of a co-working space in Denver. The company had 3 listed employees, none of whose names she had encountered before. The posting was for a senior AI systems engineer. She read to the 3rd paragraph. The successful candidate will be responsible for leading development of a proprietary adaptive inference framework capable of real-time contextual learning without retraining cycles. The exact sentence, word for word. The same 3rd paragraph that had been in the Vance Systems posting 14 months before she walked through their doors. She looked at the company's incorporation date. She looked at the 3 employee names. She looked at the co-working space address in Denver. She opened a new browser tab. She looked up the co-working space's tenant list. The 3rd name on the tenant list was a consulting firm she had not encountered before. She looked up the consulting firm's registered agent in Colorado. The The registered agent's address matched the address of a different shell company, incorporated in Delaware, that had been dissolved 18 months ago. She looked at the dissolution date. She looked at the date that company had been dissolved, 1 week after the race indictment. She sat at her new desk in her new apartment in Austin, Texas, on a Tuesday morning in April, and she looked at the job posting with the exact third paragraph, and she felt something she could not quite name. Not quite fear, not quite its opposite, but the specific vigilance of a person who has learned that some problems, when you solve them, simply generate the next version of themselves. She picked up her blue pen. She wrote the date at the top of a new page. She underlined it twice. Then she began to type.